Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. First case on the calendar for oral argument today is People v. Campbell. It's case number 481. Good morning, Councilor.
Good morning. Fabian Santacroce for Mr. Campbell. My plan was to briefly touch on point one and then get to the heart of the issue, which I think point 2 and 3. The waiver of appeal does not forfeit a claim of ineffective assistance of counsel or a challenge to the denial of his statutory speedy trial motion. The court specifically told Mr. Campbell that he could raise a claim of ineffective assistance of counsel without limitation. And further, the oral waiver did not encompass a challenge to the denial of his statutory speedy trial motion. The court said Mr. Campbell is giving up the right to make many challenges, but not all of them. And then most importantly, and I think lastly, the court stated the pretrial issues, the issues regarding some of the evidence, those issues you may lose. I can believe that's too ambiguous, and I don't think it provides a sufficient assurance that Mr. Campbell knowingly, intelligently, and voluntarily gave up his right to appeal the statutory speedy trial motion. Further, we don't have a written waiver of appeal here that could cure those errors. We did everything we could to try to find it, and unfortunately, between me and the DA that did the stipulation, we were unable to find it, even though it was actually marked as an exhibit.
We'll assume that we get to the merits. Do you want to talk about your discovery?
Yes. So I think it's important to note here that this case did come before the reforms to the reforms. It started right when CPL Article 245 came into effect, as well as CPL 3030 sub 5. And I do think it's clear from the record that the trial court and the attorneys perhaps could have had a better understanding, or were not adequately familiar with that. That said, they of course did not have all these cases that we have now to guide us. I do want to note that I did read Burroughs and Radford yesterday, because obviously I think that does change some of my arguments today. But I do still think the court below erred in finding that the certificate of compliance was proper, and that therefore the prosecutor's statement of readiness was not illusory, and then summarily denied Mr. Campbell's statutory speedy trial motion. First and foremost, CPL 245 applies to this case. I think that's in essence conceded by the DA. People v. King is not, I don't believe, on point here.
Speaking of recent cases, did you have a chance to look at People versus Fox and People versus Perry from this court?
No, Your Honor.
Okay, because that issue came up, because King in the footnote number 2 that you're probably familiar with, the Court of Appeal.
Yes, I am. Yeah.
That it wasn't taking a position on whether the discovery laws apply, whereas here the people announced readiness prior to January 1st, 2020. So they said we'll leave that for another day.
Okay. Sounds good.
But in King and Fox, in King, Perry, and Fox, the ruling was if the people announce readiness before the statute and it's not challenged, then there's no speedy trial issues.
Right. And I think what I said in my brief, and I still think this stands, is we had a superseding indictment January 24th, 2020.
Okay.
And I think it's very important to note here that trial readiness that was on the first indictment, December 20th, 2019, and the drugs possessed changed. So the first indictment alleged cocaine because that's what the drug field test said. And then we have a superseding indictment, January 24th, 2020, where the drugs have now changed from cocaine to ANPP, which I honestly had never heard of, as well as fentanyl. So I would say that December 20th, 2019's statement of readiness pre-245 was illusory based on the fact that the drugs changed, which clearly to me means that they got the actual drug testing back from the lab. So that's why I don't think King applies to this case.
Okay.
I also think this was preserved when you take together the written motion and the oral argument from the defense attorney, challenges the COC, requesting an inquiry that was never done, a 3030 sub 5 inquiry that was never done, asking for dismissal, and then the alternative requesting sanctions, one of which there actually were one sanction done by the court. timeliness. Obviously, the DA did not think it was timely. The court makes some comments about, this being raised literally at the last minute and prevents me from being able to do an adequate job of assessing this. But this case did occur prior to the 2022 reforms that, put that onus on the defense attorney to notify or alert. So I don't think Mr. Campbell's motion was statutorily untimely, but if this court finds that it's untimely by doing it on the eve of trial, then I think that goes to ineffective assistance of counsel.
So counselor, if we agree with you, you're exposing your client to a retrial where you get 19 years and you got 6 on this. So what are you looking for
Well,
in terms of a sentence if we were just to address that?
Your Honor, as you know, we discuss these things with our clients. We tell them risks versus rewards, but Mr. Campbell did wish to proceed with this appeal. So that wasn't my decision. That's his decision to put for that risk, if you will.
But the second part of my question, so if we didn't agree with you on and just agreed that the sentence was too severe, what are you?
Well, unfortunately, the range on this for him as a violent predicate was 5 to 7. So they gave him 6. So I didn't make a harsh and severe because it was just 1 year less. And I didn't think the court would be amenable to that. But so, you're right. He was looking at consecutive time, of course. But there was a lot of things missing here. And that kind of takes me to there, whether it's on the defense attorney for waiting until the last moment to bring up these issues, or whether the court didn't understand or the DA didn't. We have things that could have given Mr. Campbell a better idea of how strong that case was, or if there was impeachment material.
Right. Well, if he wins on the discovery issue, he doesn't have to worry about time. The time is dismissed.
Well, I think it is, but I think you probably have to send it back for the court to do that 30-30 analysis. But yes, there's a lot of time here.
Maybe some time is
Perhaps.
Can I just clarify what?
Yes.
The evidence that you say should have been turned over sooner and wasn't. It was the defendant had all of that prior to the scheduled trial, or no?
He didn't have all of the records from RPD regarding the medical leave. The defense attorney ended up subpoenaing that like 2 weeks before trial, getting some of it, but the city of Rochester said they would not give everything. They gave some, but not all. And that's when Judge Randall said, I'm sorry, this is too late. This is
Anything else? There were some things that were late, but anything else he didn't have at all?
No, Your Honor. I believe that the medical leave records from RPD were what was missing by the time, and there were the medical records from the treatment he got after the fact as well, which Ms. Cianca incorrectly subpoenaed, sent to the wrong place, if you will. So she never ended up having all the medical records. She had the initial ones from the injury, the day of the injury when he went to the hospital, but then there was some follow-up care, and that was never provided by the DA, nor did Ms. Cianca end up obtaining it because she ended up sending the subpoena to the wrong hospital. So we don't have that either. So we didn't.
But the disciplinary records, there's no issue here.
Yeah. So the disciplinary records, I think I'm out of luck because of Burroughs. But I do want to note Civil Rights Act 50A was repealed in June of 2020, and the DA does not give those until 8 months later and doesn't even do a supplemental COC. So it's a little different than Brown, which is what's being adopted by Burroughs. So I just want to note that, so I know that it's all about the initial COC.
I'm just trying to get a sense of what your client, when he made the decision to plead, what information he didn't have. And it sounds like there's some records from the city of Rochester. You got
regarding
partial records, but not all of them regarding the leave that the officer may have taken because of the injuries.
Yes. And why that's important, Your Honor, is because there was some paperwork about back injury from the day of the incident versus neck, knees, and head. That's different. That's like the record is, goes kind of all over the place, but that's why those records are important, because there's one letter that the defense attorney was able to get from her subpoena that discussed a back injury, and the other discussed an injury to the neck, knees, and head. And I think neck, knees, and head is more consistent with what I saw in the felony complaint. The back injury is not. So we don't have all of those. And then again, we don't have the follow-up care medical records, which based on my reading of 245, it perhaps was on Ms. Cianca to get those, because she also could have subpoenaed them, which goes to ineffective assistance of counsel. So in essence, I think my stronger argument is that the records from RPD regarding the medical leave was impeachment material. And I think that's what makes the COC invalid. And that that is my strongest argument for that. I do think on the disciplinary records, perhaps it needs to be sent back to decide if there's a sanction based on my reading of Burroughs and Radford. Because in essence, we have to decide whether that late disclosure of those things, 8 months after Civil Rights Act 50A, no supplemental, that goes more to sanctions than it goes to 30-30, based on my reading of Radford and Burroughs together.
I just have one question.
Sure.
Regarding your reliance on the superseding indictment on January 24th.
Yes,
That's by my count, 17 days after the certificate of compliance.
no, Your Honor.
It's January 7th. Am I wrong?
No, that's wrong. I actually am glad you brought that up. No, January 7th is the initial disclosure date where they never check the COC box or the statement of readiness box.
Right.
Yeah, that's not a statement. That wasn't a COC. It was just it was this discovery disclosure letter, but they didn't announce readiness yet. They didn't announce readiness until March 2nd.
Okay.
Yeah, so January 7th was they couldn't announce readiness yet because obviously things were outstanding. So they did send initial discovery and it's called a certificate of compliance on its head. But if you look at the appendix, the January 7th, it was just a disclosure letter. Go to the last page of it. You'll see that COC is not checked, neither a statement of readiness. He doesn't send over a COC or statement of readiness until March 2nd, 2020, when he sends over the grand jury minutes to court and counsel.
So the timing that we should be looking at under your view, January 24th for the superseding indictment, March 2nd for the announcement of readiness.
Correct.
Okay.
Just from my recollection, did the charges change at all between the statement of readiness in 2019?
Yes.
Well, you said it was drugs and drugs.
No, the counts.
Drugs changed, but did the charge change?
Yes.
As far as.
Yes, it did, Your Honor. There was one count of.
To what?
It went from one count of CPCS 3 to one count, I think 2 counts of CPCS 3 and 1 count of CPCS 4. So it was 2 of the counts were for fentanyl and 1 was for ANPP. I believe the first indictment had just 1 count of CPCS 3 for cocaine.
Thank you.
But your general point is that the announcement of readiness on the first indictment in December of 19 can't be a valid statement of readiness for the superseding indictment. That's where you get out of the King bind.
Absolutely. I don't see how that declaration of readiness could be anything but illusory when the drugs change afterward.
Look at that. Thank you very much.
Thank you.
Good morning. May it please the court, Bridget Field on behalf of the people. I would argue that the waiver was good, that the appeal waiver was good in this case. We unfortunately do not have the written waiver. It's clear that there was a written waiver executed, but despite all efforts by both counsel, we were unable to obtain that. But
the oral waiver there was some language there that the court accepted some issues from the scope of the waiver, right? The court said you could still challenge the effectiveness of your attorney. And there's some other issues that survive.
He did, but he did specify constitutional issues, and he specified that certain issues were waived and certain issues could go forward. He did say effectiveness of your counsel.
So that was speedy trial.
He did not specifically say speedy trials. I just looked at, and my recollection is that he did not say that speedy trial survived the appeal waiver, that statutory speedy trial would survive the appeal waiver. So I do believe that the statutory speedy trial at the least was covered by the waiver of appeal.
We don't even know if the written waiver would have corrected some of those defects in the oral estimate.
Unfortunately, we do not. And I know that both counsel turned over every stone they could in an attempt to locate it. So
basically we have to go forward with, there wasn't any.
Unfortunately, I would agree that that's the case.
Thank you.
You want to address this issue of the superseding indictment, whether the announcement of readiness from before the statute is taking effect, is that still valid in your view?
I think it was. I think it was valid at the time. I think that at the time that the people made their statement of readiness, they were ready. I think that the superseding indictment came into play because information came to light that, that the initial field testing was incorrect as to the type of drugs, but as to everything else.
They didn't have to announce readiness again on the new charges and the new theories and the new drugs.
Hindsight is 2020. But I think that the people did an adequate job in this case. And in this case, the materials that Ms. Santa Croce was referring to, the records regarding Officer Bostic's medical leave and subsequent treatment, Judge Randall did preclude those. When they had argument on this, the people were precluded from
Right, so that's a
using that
snag, but they
information.
want speedy trial, because speedy trial gets you a better result in some cases. So
Potentially, yeah.
if they were discoverable and they should have been turned over sooner, and they were turned over late, then there may be a speedy trial issue here, right?
We don't have a calculation of time in this case.
Right, so we could remit it for that.
So obviously, I'm requesting that the court affirm the decision of the trial court in this case. However, if I'm incorrect and this court were to reverse on this issue, I do believe that it would need to be remanded for a time calculation by the trial court in this case.
Right, but you're not asserting that this information that was turned over closer to trial, the people didn't have it in their possession when they filed their COC? Or that you're not making that argument?
I
Because if they didn't have it in their
can't say that they
possession-
did because
Yeah.
this is, I'm not sure, I can say that I'm not sure on this record what the length of time that it was for Officers Bostic's for this ongoing treatment. So he was injured the day of the incident, the day that the charges arose, but they're asking for his subsequent medical care and medical leave.
But you're
So
not-
that was ongoing.
And that wasn't in the people's possession when the COC was, I mean, these are all issues, hindsight's 2020. I'm not criticizing the trial judge, the statute was new, but
Correct.
if we could go back, maybe some questions would be, these records that are now being turned over, when did you get them? Asking the assistant DA, when did you get these records? Where did they come from? Some evidence is presumed to be in the people's possession from the beginning.
Correct.
Does this fall into that category, or is this after COC obtained evidence? Those are the things that are a little unclear.
Correct. And I do not believe that those answers can be answered from this record. There is, again, I don't have the dates from the record, the dates that are in question as to Officer Bostic's continuing care is not in the record. So I can't
Well-
stand here based on this record and say when they would have been available to anybody.
Well, if King applies and Fox and Perry, our two recent cases apply, then it doesn't matter. But this is, counsel raised a legitimate point that I hadn't considered, was there's a superseding indictment. That's what factually distinguishes. Maybe the result doesn't change on that, but I don't believe we had a superseding indictment after the statute took effect in those other cases as we do here. So we're gonna have to take a look at that twist and see where it comes out.
I would agree, Your Honor. And as to ineffective assistance of counsel, I would argue that this ineffective assistance of counsel did not affect the voluntariness of the plea. So that's a consideration.
He did move for a speedy trial dismissal, didn't he? The indictment.
Yes,
Turn.
yes.
Did he ever ask for more complete medical records on the different injuries of the officer?
There was discussion about the medical records and how they were going to be obtained. And I believe, as Ms. Santa Croce said, that it appears that Ms. Cianca may have requested them from the wrong entity. But my understanding is that she did in fact have them by the time, prior to this plea. This discussion was, this argument was held, I believe, pretty close in time to when the plea was taken. But my understanding is that she did get them. The judge had offered, if I'm recalling the record correct, that he would sign a subpoena right away.
There is an exception for discovered materials that are available by subpoena under, I think it's 245.
Correct.
52 or 245, one of those statutes that talked about,
Correct, Your Honor.
it's, people don't have to turn it over if it's available, if the other side can subpoena it. Medical records would seem to fall in that exception. But it's yet another unexplored issue here. So there's a lot here we'll have to unpack.
Yes, Your Honor. If there are no further questions, I would rest on my brief for the remaining 10
Thank you
minutes.
so much.
Thank you.
Case number 486, People versus Manuel. Jameson and Manuel.
Yes, Your Honor. May it please the court, James Eckert of counsel to Andrew Correa, Wayne County Public Defender for Jameson and Manuel. I submit that the statement here should have been suppressed. There was no Miranda. I believe the officer's statement was the equivalent of police questioning the insistence of the prosecution and the officer that Mr. Manuel had asked what his charges were. I think is incorrect. He said, "You didn't tell me."
Didn't he start the questioning then?
He didn't start the questioning, and I think
Isn't that a question?
no,
What am I charged with?
no, but see, that's a question.
That's-
And if he'd said that, I think we'd have a different situation, but you didn't tell me what my charges were. And I think what's important is that a plain question is something the court, that the officer can simply answer, but a statement by the defendant prompts the question of whether or not the officer's response is the functional equivalent of questioning. And it's not a case where the officer's statement has to be somehow unreasonable or inappropriate or whatever, but he's making a choice to engage in questioning without Miranda. And that's why I think every time they say the defendant asked what his charges were, that's not what happens. They're changing it for a reason. And I submit that's the reason why.
Doesn't the CPL in his 14015 say the law enforcement is required to inform the defendant of the nature of the charges upon arrest?
Right, and the people, and I would ask the court to look at the record. I don't recall that having been argued below. But I submit that, even informing him of the charges under the circumstances here can be the functional equivalent of questioning.
But was it, so if there's no Miranda and the police make statements that is intended to elicit an incriminating response, then there's a Fifth Amendment violation. But here, was it intended to elicit an incriminating response, and did it in fact elicit an incriminating response? The response from your client was, "There's no gun in the car." Is
Right.
that
Under the circumstances of this case where there's an extended following of the defendant and the allegation of the police and the finding of the gun on the route that he tossed it out the window, his statement that you're not going to find a gun in the car isn't really helpful for the defendant. So yeah, I think they introduced that for a reason.
It doesn't hurt him, right? I mean,
It does, it hurts.
how does it hurt him?
Because it gives the implication, I think the analysis would be, and I think the argument of the people at trial was him saying, "You're not going to find a gun in the car," means I tossed it out the window when I was being followed by the police. So
I guess, or another way to look at it is that he didn't have a gun in the car ever, but.
I mean, there's innocent interpretations, but the other interpretation is the one it was introduced for, and I think that it's not harmless. I think in the introduction of the statement.
Trying to understand the appropriate response by the police officer, the statement that the defendant made, "Man, you didn't even tell me what the charge is yet."
Right. Are you asking me what the charges are?
All right, so now you're suggesting the police officer should have responded to the statement with a question.
Not responded at all. I mean, the cases that sort of make an exception for the police to answer a question from the defendant don't apply if the defendant doesn't ask a question, which I think is why they kept saying he asked what his charges were, because he didn't ask what his charges were.
Well, he wasn't being interrogated at a time, right?
No. And also I think the cases are also clear just because.
Throughout that.
Right. Just because the defendant begins the conversation doesn't mean that all, you know. that
What's your
we're open
suggestion?
for-
Once he makes that suggestion, that question, that now I gotta Mirandize you?
Or are you asking what your charges were? I mean, if he gets a plain question, he gets to answer it. I think that's clear, that the defendant who says, what are my charges? The officer can just tell.
You're suggesting that a clarifying question is better than responding criminal possession of a weapon 2 counts?
I mean, a clarifying question at least puts him in a case where he's answering the defendant's question. Because right now he's just making a statement which is reasonably likely to elicit an incriminating response, and which the officer knows is reasonably likely to elicit an incriminating response, and you know, and not in response to a question. I mean, he keeps saying, he asked me what his charges were. He could have. So with regard to people were also allowed to put in the complaining witnesses multiple statements, multiple witnesses saying she identified the defendant. The 911 was an excited utterance, but after having spoken to 911, these were not, there was time for reflection, and there shouldn't have been repeated introduction of testimony, people saying Jameson shot at me. This was preserved.
911 recording introduced into evidence at trial.
Yeah, I believe so. I know there was testimony about it.
Would you agree that that was an excited utterance? She just got a bullet whizzed by her face and she almost killed her daughter was inside. She calls 911. That's an excited utterance, right?
Yeah.
But I'm not.
And that was objected to.
I'm not 100% sure that evidence was admitted at trial, that statement. I could be wrong, but I looked at that. I wasn't sure. The second, she repeats it to the deputy who arrives, the sergeant, shortly thereafter. That one's a little closer, right?
And calls her daughter, I think, the intervening. So
right, and then her daughter testifies.
Right.
So those two are a little closer. But if the first one is admissible, if the 911 recording did come in, would it not then be harmless? The jury's hearing the same thing that it already heard properly.
Well, first of all, the problem here is the complaining witness, who is just awful. So if you've got multiple bolstering of her saying Jameson shot at me, I think it matters that there's more than one. So having it come in 3 times is helping someone who is just a terrible witness. And the case was not overwhelming because
You're
even
saying she's terrible because of her background. She's a liar, a thief, and a cheat. That is what the defense attorney. But are you saying she was a terrible witness to?
Yes. Yes, because the defense says, because she talked about, you know, her prior dishonesty and so on, and the defense asks, when did you last lie? Said, I was untruthful today. What? I was untruthful today. The DA tries to rehabilitate on cross-examination. I never said I was untruthful today. It's twice in the transcript. I mean, there's 2 pages. She denies saying something that she just said to the jury. I don't think I've seen anything bad that I can recall. So, and she is critical to, if she's not in the doorway, it's not attempted murder. If it's just shooting up the house, it's not attempted murder. And if it's not him doing the shooting, it's because he's charged only as principal. So if he's hands the gun to the other person in the car and she shoots and so on, he's not guilty. So her testimony is critically important. So everything that bolsters her, I think is not.
I think I read your brief correctly, is you're not disputing there's overwhelming proof, let alone proof, you know, clearly proof beyond a reasonable doubt that your client was in that white Mercedes when the shots were fired. You're saying the people didn't establish beyond a reasonable doubt that he's the one who pulled the trigger, right? Is that how I read it?
Right. He's charged only as principal.
So he's there. I mean, look, the evidence.
I mean,
we have his phone records. We have the tracker. We have
the circumstantial evidence is so I wouldn't concede it, but
right. So she wasn't lying when she said that a white Mercedes with your client pulled up in front of her house in the early hours of the morning. Somebody from that car fired multiple shots, 7 shots, I think, in her direction. Right.
Well,
so he wasn't lying about that. We know that.
Except I wouldn't draw too much from that, because given the history of these 2 people, if somebody's shooting at the house, I don't know that she needs to see much of anything to guess that she's going to blame Mr. Mack.
There were text messages, weren't there, from your client's phone that said, I just tried to gun?
there was text messages from a phone identified as Jameson, so.
And he had threatened her. He threatened to, she owed him money for drugs, according to these text messages. And he threatened to do some dastardly deeds. I don't really feel comfortable mentioning it in a courtroom, but, and there's no dispute that that all happened. So really, if she were mistaken or lying, she got everything else right. Your client was found in a white Mercedes that early, like 3 o'clock in the morning, not far. If she was lying or mistaken about anything, it was only with respect to he was in the car, but maybe somebody else fired the gun and not him, which would probably still subject him to accomplice liability anyways, but so why?
I mean, he's
would-
charged only as principal, so the
Right.
charge to the jury.
But if she was trying to get him in trouble, she got an awful lot of things right that she didn't have any reason to know were going to be right when she sent him to the police.
Well, I mean, there was a dispute about which way the car was, inconsistency about which way the car was facing, which becomes important if it's somebody else doing the shooting. And also where the car, because she's got him being in the driver's side, reaching across where the gun in her testimony is inside the car. So the shells aren't going to go outside the car, and the shells are all over the street. So that kind of implies either or both that the car was facing the other way or somebody else is doing the shooting. So
Right. At best for your client, he was in the car early hours in the morning with somebody who shot up the house. And maybe it wasn't him who pulled the trigger. That's the best case for your client.
I mean, outside of her testimony, and which support from some of the circumstantial evidence about the phone and so on, I'm not conceding that he's in the car at the time of the
Right.
shoot.
But that's not the focal point of your argument.
Right, correct. And also, I think the give and take with the jurors was improper. And by the time the court had effectively informed them that they couldn't have the written instruction because the defendant wasn't consenting, there wasn't an objection or a means of fixing that the defense could ask for. So I think that would be a reversible error as well. Thank you.
Thank you.
Good morning, Your Honor. So Michael Tantillo for the respondent. It sounds like defendant did not argue weight of the evidence, the first point in his brief, but that certainly has come up in the course of your questions from the court. So I would just simply reiterate the points that have already been made by the court, that in addition to the very direct testimony of the victim in this case, that she saw the defendant point a gun at her and fire multiple shots at her from a white Mercedes, there was a wealth of additional evidence that corroborated what she said. And I won't go through it all because you've kind of highlighted almost everything that was significant.
And one piece that I did misstate, and
Sure.
got confused with the case from the other day, is that she didn't owe money for drugs. He had borrowed her card, wouldn't give it back, and she went to the police, filed the police. That was the motivating alleged motive here, not that she owed him money. So I just wanted to correct.
Yes, I don't think there was any evidence in the
Yes.
record that she owed money at the time. But as you're pointing out, even though motive is not required to be established by the people, there was a great motive in this case. He was retaining her car. She had made multiple efforts to get it returned to her over a course of several weeks, and he continued to refuse. So she reported him to the police and told him, "You're going to prison unless you get me this car back." In response, he fires threats. He texts and states over the phone multiple threats to her, including her family, as you've indicated, Your Honor. And not only does he do that, in his last text message, he reiterates the threat against her family member for reporting him to the police. So a pretty strong motive testimony here as well, in addition to everything else. The tracking the defendant, the fact that surveillance videos showed the white Mercedes driving right by the victim's house at 20 minutes to 3 a.m., exactly when she said the shooting occurred, tracking him from that location to a couple of miles away where he was arrested, the gun being found along the route that he had traveled before he was arrested. I mean, really, there was
Cell phone tracking.
overwhelming. Pardon me,
The
Judge?
cell phone tracking data had his cell phone
Yes.
going right by the route. But what about this issue of, well, he was in the car perhaps, but somebody else may have shot. And the fact that the shell casings were outside the car, and if he was in the driver's seat because he was alone in the car, according to her, he was alone in the car. How did he reach all the way out the passenger side window? What do you make of that?
I would say that was unclear from the record. Now, the victim testified that she only saw the defendant in the vehicle. She didn't see anybody else in there. So whether there was somebody else at the time, his girlfriend or not, it's unclear. But with regard to the shell casings, what wasn't mentioned is that the forensics expert testified that when this handgun is fired in the test fires, the shells eject outward and to the right, up and to the right. So if someone is pointing the gun out the passenger window, which the victim said that's what the defendant was doing, you would expect the shell casings to be ejected out that window. I think that's perfectly consistent. The forensics testimony is consistent with what the victim testified to. 20 minutes later, when the car stopped, the defendant's girlfriend's behind the driver's seat, the defendant's in the passenger seat. Whether he was alone at the time and driving and extended his hand out the window, or whether he was in the passenger seat while she was driving, but the victim didn't see the driver, was unclear. The point that was clear is that the victim testified unequivocally that the defendant pointed the handgun out the passenger window and fired a fusillade of bullets at her from that white Mercedes.
Can I ask about the Orama violation?
I'm sorry, the Orama violation?
Yeah.
Sure, Judge.
So I appreciate the fact that when the foreperson asked for the elements to be written down, all counsels present in the courtroom, defendants in the courtroom, jury's there. I mean, everyone's there. And so that seems like it feels a little bit harmless, but the way that the court reacted to it with some uncertainty, and that's okay for judges to be uncertain. But what that ultimately led to was an objection that had to be made in the presence of the jury by the defendant, saying, essentially, giving the jury the impression, perhaps, I don't want the jury to get the elements. Now, the defendant may have had a great reason for that the jury never found out about, but the jury then goes back into the room thinking he doesn't want us to see that. You know, and a lot of times trial attorneys will say, well, I'm not going to make that objection because of the impression the objection gets, but here the defendant had to, was sort of stuck because of the way the judge mishandled it. Should we reach that in the interest of justice? I know it's not preserved, but
You're right, it is absolutely unpreserved, but I'm going to take issue with just one caveat of yours when you said that the defendant objected. He actually did not object. I think his precise response was when the jury says, can we get the written elements, please? And the judge's response is, I think you have to consent. And it's not clear in the record who he's talking to, whether he's talking to one side or both sides. But the immediate next response is from defense counsel who says, not by me, Judge, can we talk at the bench? He never really objected as such. So then they have a conversation at the bench. And even before that happens, the judge tells the jury, you know what? I don't think I can give them to you. And then they have a conversation at the bench. And then they have they excuse the jury and discuss it further. And the judge makes clear that he's not going to, the very next day, he takes great pains to tell the jury, I'm not permitted under the law to give you these instructions in writing. Almost every jury asks for the same thing. I'm sorry, I wish the legislature would let us do this. I can't. So first of all, I'd say there's no error. There's no foul, no harm.
and to the extent that that gave the jury a misimpression at the moment, it was corrected the following day.
I would say so. I would certainly say so. And again, you know, harmless error analysis has to, of course, be considered in light of the overwhelming nature of the evidence in the case, which I'm again arguing is in fact overwhelming. The only other topic raised by counsel, which I'm going to be very brief on, is the statement made by the defendant in response to the officer saying, you're charged with 2 counts of criminal possession of a weapon second. As I indicated in my brief, I don't think there is one case in the reported jurisprudence of New York State that has ever held a police officer telling a defendant what the charges are to be the functional equivalent of interrogation. And that's in cases whether it was preceded by a question from the defendant or whether there was no question from the defendant. So I just submit there's no support to that.
There's a statute that requires the police to inform the defendant. I don't know if that
And you know what?
results in suppression if it's not followed, but it is right there in the CPL.
And I have to confess, Your Honor, I didn't think about that until you mentioned it. And I wish I had thought about that and put that in my brief. But you're absolutely right about that. It's an obligation imposed upon the police to let the defendant know what he's facing.
Thank you very much.
Thank you.
Case number 487 is People versus Huntington.
Handling Your Honors, Paul Skip Leisure on behalf of the Wayne County Public Defender
So
for
we just-
Mr.
Hold on,
Huntington.
we have some people leaving the courtroom. I just want to make sure we can all hear you and everyone. at home can hear you. Your opponent has submitted, but you are free to argue.
Thank you. I'm going to focus on the first appeal in this case. The trial court, relying on a plea agreement, did not actually consider whether YO treatment was warranted. The parties agree that Mr. Huntington was eligible, and they also agree that a negotiated plea that says you don't get YO is unenforceable. The question is whether the trial court actually considered giving YO, and I think the record demonstrates that the court did not do so. The court, started out by, well, first the prosecutor started out by saying the agreement says consider and deny.
But didn't
That
the court,
that doesn't.
the court explicitly say at sentencing is analyzing the YO status notwithstanding the plea agreement? Isn't that in the record?
Yes, but the problem is that the court preceded it by saying the appellate courts and require me to put reasons on the record. So here are the reasons. That's not the same as.
Isn't that him acknowledging his responsibility?
It's acknowledging his responsibility to put reasons on the record. It does not acknowledge his responsibility to make an independent judgment about whether YO should be granted in the case. Rather, he was relying on the parties' agreement.
So your request is we remit it for him to make another decision, but this time make it more convincing that it's actually his decision?
Yes, and there's an additional aspect to that. I don't believe this court has gone there yet, but I would ask it to follow the first department's lead in the cases I cited on page 12 of the brief, that when there's, if the court decides this is ambiguous, that's not enough. That has to be sent back for that reason as well. So
Well, we could, I think you also may ask us, we often get asked to just substitute our discretion right here and now and do it.
I'm sorry, Your Honor.
Are you asking us, we have the authority to substitute our discretion and grant your client youthful offender treatment right here and now? Are you asking for that, or you just want it to be remitted to get another no?
I am asking for that, but I remind the court that there was a waiver of appeal. And so that may foreclose what's possible. Of course, I would ask the court to look at that waiver and see whether I missed something.
Does the waiver encompass this issue?
I believe
Either one of them, because you got two, is one, the court didn't actually make its own decision, and two, you could ask us to substitute our discretion.
which I have asked.
Yes.
Yeah.
But you just said that it might be foreclosed by the waiver of appeal. Wouldn't the waiver cover both of those?
No. The Patcherville is a court of appeals case that says this does not cover the first.
Okay,
Yes.
so, all right, we understand that. Anything further?
Yeah, the only other thing to point out is that this would not be an exercise in futility to send it back. The court did say reasons why YO could be denied, but there are also several reasons why it might be granted. And if the court felt free to do so, might consider those. And that is the abuse of as a child, no stable home life. He had an IEP in school. He had all kinds of mental illness issues and substance abuse. So there's a lot going on there.
Right. Thank you, counsel. Case 489, matter of Jamori DS. 489. Ms. Waldman is remote. Everybody else has submitted. Counselor, good morning.
Good morning, Your Honors. May it please the court. Kara Waldman representing Alejandro Diaz. Briefly, regarding point one, although Alejandro's attorney filed an acknowledgement of paternity for Zamora during the pendency of these proceedings, he never acted as her parent and was essentially her parent in name only. He was also not a person legally responsible for her care. In fact, the uncle in Yolanda D took on a more active role in the child's life than Alejandro did here, where he did not live in a familial or household setting with Jasmine and Zamora. He was not in a relationship with Jasmine when Zamora was conceived. He was living with another woman. He did not go to any of Jasmine's prenatal appointments, and he was not present for Zamora's birth. Alejandro did not spend any meaningful time in Zamora's life, only seeing her.
Counselor, just comment. Shouldn't be using the children's names, just their initials.
Oh, I apologize.
Okay, that's okay.
One piece of mail not admitted into evidence in one suitcase is not enough to show that Alejandro lived with Jasmine and Z. Regarding point
Wait a
two,
minute, wait, you did it again. You're mentioning the children's name.
I'm sorry, Your Honor, Jasmine is the name of the mother.
Okay, because there's a Yasmir. Okay, go ahead. All right.
Regarding point two, even if DCFS is able to meet its burden, Alejandro was able to rebut DCFS's evidence of abuse because he was not there when the incident occurred and Jasmine had a reasonable explanation for Z's injuries. The First Department's decision in matter of Sean B is on point here because the girlfriend in that case was not responsible for the abuse that occurred when she was not present. This is not a situation where Z's injuries occurred over a sustained period of time, but constituted one discrete incident. Regarding Jasmine's reasonable excuse for Z's injuries, I note that DCFS did not conduct a thorough investigation to confirm or deny Jasmine's story of the events as she said they occurred, or even measure the height of the bed. Wallerstein's expert opinion was flawed because it was based on incomplete information and assumptions she made, including the height of the bed. Most importantly, DCFS's experts conflicted with each other with respect to whether this was an abusive head trauma case or not. And lastly, DCFS had no evidence linking Alejandro to the gun. I refer the panel to my brief regarding derivative neglect. Thank you.
Thank you, Counselor. Our next case on the calendar is 492. Matter of William C. 492. All three attorneys are virtual. We're waiting for Mr. Broderick. We have counsel. Ms. Argy, you may proceed.
Thank you, Your Honor. May it please the court, Kellyanne Argy for the father appellant, Chad C. We would like to draw your attention to 3 points in this case. And the first is that there was no finding of best interest of the child to terminate this father's rights. There was nothing in the record that
Counsel,
said,
was that, I'm sorry, just on that point, was that raised for the first time in reply?
it is raised first time, well, in the reply, it is emphasized. And I believe it is raised in the record at the very end. I'd have to re-review that. But in our papers and what we have set forth, yeah, that is correct. And we raise it in the reply because we do feel that there was enough evidence presented and enough said in the first brief that there was no testimonial evidence regarding the child's relationship with the father, no testimonial evidence regarding the child's bond with the father, no testimonial evidence with the child's relationship with the foster care family or any bonds with foster care family, and no real testimony regarding his relationship with the step sibling, and no testimonial evidence regarding the effect of the termination that it would have on the child. And most of that is spelled out. We did a very detailed statement of facts in this opening brief. And as this court knows, at any stage of the proceedings, a finding is required in order to be able to terminate the rights of the parent. And it leads us to the other 2 points that we'd like to make and draw your attention to. One is that the father's progress was completely dismissed by the court's decision. The father's progress, if you'll recall, as you review this, the child was originally removed from the father, and he was, as he concedes, very volatile, but he also had a drug addiction. And early on, he successfully conquered that drug addiction. That's just first and foremost, that one of the main reasons that he was the way he was that drug addiction, and he conquered it, and there was no concerns about drug use throughout the rest of the time he was in the system, which is over 4 years. He also successfully completed all of the respondents' requirements and mandates throughout this entire invasive proceeding in which he was monitored. And at the end, he voluntarily continued with his counseling for purposes of anger management. He knew. And I do want to say that he also, as much as he concedes that he was extremely volatile in the beginning, there was tremendous frustrations throughout this, where he was violated for something that he was found not guilty for, but the child was withheld for 5 months from him. And it is very clear from this record that this father was very engaged in trying to keep this child. And he continued with that counseling for purposes of making sure that he could have that child returned to him. But how that relates is that he modified his behavior throughout these 4 years. I think you can see from the record that his outbursts decreased. And this is the kind of progress that is noted in some of the case law, and we specifically mention the matter of Nalaya MM, where the court finds that, you know, it's a little premature to terminate the suspended judgment when the parent is successfully moving forward with their progress. And in this case, this father truly was. But that leads to the other point. The court's decision is very inconsistent with the evidence, as we laid out in the opening brief. A lot of detail went into the statement of facts and the testimony because there's so much inconsistency. First and foremost, the father.
One thing, two points I just want to ask you before you get into that next topic is with respect, first of all, to the finding of permanent neglect. That was done back in October of 21, and I know the DSS appealed it initially, as did the AFC, but the father didn't appeal that. So I don't know if we can reach that issue, and I'll give you a chance to talk about that. But with respect to this idea of conquering the anger issues, we have the suspended judgment granted on November 4th, and then we have testimony, I think from Ms. Main from DSS. It indicated that the father threatened her in the same month, November of 22, with the phrase that he's going to take her out. I'm going to come after you and take you out. And that seemed to be something that made an impression on the court. I mean, how should we consider that?
Well, let me take you back a little bit. So you said Holly or Miss Main, who is the father's counselor, and I think you meant the caseworker, Miss Kelly.
Thank you.
And Miss Kelly definitely asserted an allegation that the father threatened her when his monitored access was removed over a rumor that he had violated the provision that he was not allowed to have the mother have contact with the child while the child was with him. And he threatened her and said, I am going to come after you, is what his words were. And he proceeded to say in court, and he did pursue her in civil court, and he did not ever touch Miss Kelly. And he continued, you can see on the record, he continued to tell his counselor, Miss Main, that the relationship was extremely acrimonious, and I don't believe he felt he could get anywhere with her on the case. And there were, again, I'm going to go back to the point that there was a violation and the child withheld from him for 5 months, and he was found not guilty of any violation. So this father was enduring a lot. And we have to remember, it's a parent. And we know that he has to be accountable for why he's in the system to begin with. But this case is a travesty because he worked very hard to get to a point that he could have his child returned. If you look at the record, even the respondent's own witnesses said there were no safety concerns. He had a safe home. It was always neat and clean. And he was.
I have 2 questions. One, which is, can you touch on the mental health treatment, whether or not dad received it, what he successfully completed? My second question has to do with whether or not this child was adopted.
So first, I believe he has a certificate for the mental health counseling. I believe he was considered to be not recognized that it was considered really not relevant because he was still having the characteristic of his volatility. I am going to stress that it was modified. You can see in the record that he tones it down. He's getting better and he's trying, and he's maintained that counseling for that purpose. As far as
And when
the
you say
child-
tones it down, I'm sorry for interrupting, but when you say tone it down, do you just mean he's toning it down in court?
No, I believe he's toning it down altogether.
Okay.
The only instance that we can really refer to where he was in this time frame where he had some volatility was when the child was removed from monitor access and he was going back to supervision and supervised visitation, and he was extremely frustrated because he was again working very hard, very compliant, and voluntarily continuing to work on his problems. All this progress was completely dismissed at the whim of the caseworker, who felt she was threatened, that her safety was a problem because he said, I'm going to come after you. And he did go after her in court, and he did, he has the history. So we understand that somebody might have intervened and said, hey, you can't talk to her like that. But he did say in court, and we don't know from the testimony whether or not he was trying to say that as he said the entire sentence. We can't know that. But we can know that this father was there was a lot of invasiveness in this entire 4 years plus. And sometimes I think we need to step into the shoes of what somebody like that is going through, who certainly conquered a drug addiction and certainly made, has all his certificates, did all the requirements that the respondent mandated, and then continued to have his visitation interfered with or removed for violations that were unsupported. Even the last violation for going in on the suspended judgment is unsupported on this record. Miss Kelly violated him on a rumor. Nobody came in to testify this is exactly what they heard. Nobody investigated. Miss Kelly concedes she didn't investigate. She did not even ask the appellant about the allegation.
Okay, counsel, your time's running short, but could you address Justice Kane's question about the child's been in a foster care home for how many years now? And is waiting some finality one way or another here. When did the child go into the custody of DSS?
Well, he was first placed with the mother's father, I believe it was, Mr. Baker. And he was then later removed from him. And I'm not sure exactly of the date, but I think it was within months. And then he's been in foster care ever since. So we're going back to 2021 at least. The child has been in foster care.
4 years. And is
Yes.
the family who he's living with, they want to adopt him? Not that it's relevant to
Yes.
you, but you're just responding to Justice Kane's question.
Yes, it is my understanding that they did want to. And before I answer that completely, what I do want to say, based on all of what you just said, is that through all of those years, the appellant father was very engaged with this child. He was continually going to all the appointments, medical appointments. He was continually pursuing his visitation. He did every supervised visitation that was mandated upon him, back and forth between, unsupervised to supervised, and he always complied, and he was always there with the child and for the child. And that has to be relevant to some extent. As for the answer to Your Honor's question, it is my understanding, I do not have actual evidence of, but I have been told that during this pending appeal, the child was adopted at the end of January. And I don't even know what to say about that, other than—
Aren't there stays usually? Aren't the adoptions proceedings usually stayed until the appellate process has been exhausted?
That is my understanding, but at the same time, I don't have proof of that. I just heard it.
Would it be moot if the child's been adopted? Would it be moot, this appeal?
Well, that is a good question, right? And I want to say to you that even if the child went through the adoption, how can that supersede how wrong that was during the pendency of this appeal. And I know that this is a lot for this court to think about, but it's not right that this parent's rights were terminated to this child prematurely under that suspended judgment on an unsupported allegation. And with all his progress, it wasn't time. And I understand it was a long process, but they are long processes.
Wasn't there other factors as well that he had to, conditions that were set on that suspended judgment? He had to present a sustainable income, and all he had was his claimed winnings from the casinos and loans from other family members. He made no real progress to overcome the specific problems which led to the child's removal. Those anger issues that persisted, continued to persist. He failed to again, learn the appropriate conflict resolution activities and failed to refuse, excuse me, to supply verifiable income. So those are factors, those are conditions that even a violation of any of those permits the court to revoke the suspended judge.
So in respect to, let's just say about the financial situation. The father owned his own home, owned his car, of things free and clear, paid all his bills.
He has a verifiable income. He refused to provide it. I'm getting loans from my family members that are supporting me this. How verifiable is that? How continuous is that?
I think the record reveals that he did not refuse to supply it. It was an excuse. He also was in support court during this time, submitted everything and paid child support. He consented to the child support and paid it.
Do you know what his source of income was? Do you know in the record indication of what his employment was?
Well, he was not employed because he was in a car accident, and he was in the disability process, seeking disability benefits, which we know takes a long time as well. So in the interim, he was certainly borrowing from his family, relying on his family, and relying on some monies that he had. He testifies that he's very frugal. He doesn't spend a lot of money, and he pays his bill because he wants to pay his bills. And remember, he owned his home free and clear. Ms. Kelly testified that the actual financial paying his bills was not a concern. So even if the court saw it as he didn't present a viable source of income, he was pursuing a disability claim, and he was still in that process, and he clearly had surgeries and an injury problem. So he was doing the best he could, and I kind of have to insert, Your Honor, is that really something to terminate your parental rights when you're working so hard to try to do everything that this system is requesting of you? I mean, think about it. Put yourself in those shoes. And he has family that's helping him. And if we are going to take a child from a parent every time they need to apply for benefits, welfare benefits or disability benefits, then there's going to be, how many kids in the system? There's so many people who are having hardships. Is that really something that's a violation?
I don't think anyone's suggesting that alone would be a basis to remove a child. But you make some very passionate arguments, and your time is up, but we appreciate everything you've had to say today. Let's turn it over to Mr. Pajak.
Thank you, Your Honors.
Good morning, Your Honors. Dave Pajak for petitioner respondent. There is a typo on page 11 of my brief. Of course, the suspended judgment was entered on December 14th, 2022, not 2023, as I said on page 11. I do have the correct date set out at page 9 of the brief. However, there is the typo at page 22. The family court judge does set out a best interest finding in his decision. It's on my brief at page 33. Now, in this case, the neglect was entered in 2020. Here it is 2025. How much more time does this respondent need? I think he's at
counsel,
the Apple.
Counsel, again, the point that's been raised, if the child's been adopted, doesn't that moot the appeal?
I believe so.
Is it your understanding the child's been adopted?
That is my belief, yes.
Is that customary? I thought that they, on these types of proceedings, there's a stay in effect, and because otherwise these would always be moved. These these termination of parental right cases would always be moot. This appears that this was an exception to that general rule.
No, it's my perception that most departments of social services do not wait for the permanent termination proceedings and the appeals to be concluded. They go forward with the adoption. It used to be called an at-risk adoption. That's no longer the case. I don't think they still call it that anymore. They do go forward with the adoptions. But in this case, well, in all of these cases, if the child is adopted, then the appeal does become moot. But it's a matter of the parent bringing it to the attention of the court and make a motion that it is moot, or the department bringing it to the attention of the court.
Or the parent could move for a stay of enforcement pending appeal.
The parent has, in other cases, parents have moved for stays. I think we recently had one in Erie County. I know it was in the appellate division. I don't recall which case it was. The stay was denied. The adoption did go forward. So I don't know, but I believe that the child.
Would the father have gotten notice of this adoption?
I'm sorry, I had to turn my volume up.
But would the father have gotten notice of this adoption proceeding?
Well, not once his rights are terminated. I believe that cuts off notice. I could be wrong on that, but I believe that once the parental rights are terminated, that cuts off notice of the appeal. They no longer.
So it'd be unlikely that he'd be able to. He'd be unlikely he'd be able to move for a stay if he doesn't know about it.
Well, that's correct. That's correct.
But he would know if he's not getting any visitation anymore, any services. But in any event, that's neither here nor there. But your argument here is that it's moot and we should dismiss the appeal.
Yeah, that is my argument. However, on this record, we have a violation of the suspended judgment. We have several violations that were proved at the hearing. You know, he's asked for an enlargement of time. I don't see, and the family court judge didn't see, where another enlargement of time is going to benefit this child or this case to any extent. He's had many chances. The department did not remove the child from his care right away, and they worked with him all that they could. And this unfortunate fellow is just resisting at every turn. He's loud, belligerent, abusive of the caseworkers, pediatrician's office, what have you. So,
thank you, Mr. Broderick. Having some difficulties. Mr. Broderick, we're having some static. Yeah, we're having difficulty hearing you. We can hear.
Your Honor, we believe counsel is having issues with his network connection.
Yeah, Mr. Broderick, I don't know if you can hear us, but we cannot hear you. You can, if you want, make a post-argument submission if there's anything pertinent you want to add to this. I would like to hear from you. If you can try to get your audio together one last time here. Can you nod if you can hear me? All right. Can you try to articulate your thoughts again? All right. Regretfully, we won't be able to entertain. All right. I'm going to ask you, there is the option of a post-argument submission that would be appropriate here if you want to add something that hasn't been said already on behalf of your client. And we thank you. We'll move on to the next case. Her argument is 495. Edward Kern versus JML Incorporated, 495. You are Mr.
Connor.
Okay.
Good morning, Your Honors. May it please the court. Robert Connor for the third-party defendant appellant Elmer Davis. This is an appeal on a decision from a Supreme Court ruling denying Elmer Davis's motion for summary judgment on the third-party claims in this action. Briefly, by way of background, as the court knows, this is a slip and fall that occurred at a property located on 34 Wright Avenue in Auburn, New York. The Auburn is owned by third-party plaintiff JJML and is leased to Elmer Davis.
Right, and the plaintiff worked for Davis, stepped out in the morning, got there in the morning, it was raining, saw a leak inside on the roof, went out to the exterior uncovered deck and slipped, he says, on thin veneer of perhaps algae or moss, and went down, and that's why we're here today.
Yes, that's correct, Judge.
You represent Davis on the third party action.
Yes, that's correct. Now, Elmer Davis leased the property under the lease agreement that was provided in the record on appeal. And JJML brought third party actions based on an indemnification clause in that lease agreement. Now, the issue we brought up in our motion for summary judgment and bringing today is that the indemnification clause does not affect this incident, is not triggered by this specific incident. The reason because of that is because the indemnification clause covers incidents that occur in the leased property.
Right, and your argument is that's the demise premises is different than leased premises?
That's correct, Judge.
There's a definition of demise premise or a description. Is there a description, a separate one for leased premises in the lease?
Under the lease defines the demise premises as, quote, the leased, I believe, 538 square feet of office space and warehouse space.
Yeah.
And what I call the right to use areas of the property, those areas that JJML has said that Elmer Davis has access to. Now, in the lease, in the indemnification clause only refers to the leased premises, not the demised premises. In every other part of the lease agreement, it refers to this demised premises.
So the demised premises, you would agree, includes this deck?
I would agree that the demised premises includes the deck.
Right, so the leased premises, which is not defined anywhere else, in your view, does not include the exterior deck?
It's my contention under the express terms of the contract that the leased property or leased premises only includes that 5,380 square foot office and warehouse space.
But counsel, let me ask you a question. In the lease agreement on it's paragraph D of, I printed out this one page, but it says tenant agrees to use and occupy the demise premises and are careful and blah, blah, that goes on. And then it says, and to keep the demise premises in a clean, sanitary, and safe condition in accordance with this lease. So why doesn't that obligate your client to make sure that it didn't have the moss or algae or whatever caused the fall?
Because there's another provision of the lease that expressly says that JJML as the landlord property owner is responsible for quote unquote all exterior maintenance. The deck is an exterior portion of the property and is therefore covered under that provision. Your Honor,
exterior, yeah, I mean, I get that. That's why there's a little twist to this case because the deck is exterior, but only Davis has access to it.
That's not exactly correct, Your Honor. JJML also had access to that portion of the property.
Well,
there was testimony that they used.
Would you agree Davis is the only tenant that had access to it? None of the other tenants are going to go through Davis's locked office space to access the deck through their office space, right?
Well, the deck is accessible through a kitchenette that is also, it's not clear under the lease if that kitchenette was part of the leased property or not. Under the testimony, there was testimony that it was unclear in the lease agreement if this kitchenette was part of the leased premises.
To get to this kitchenette inside Davis's office, another tenant would have to have keys to Davis' office, right?
I think that may be correct, Your Honor.
And there's no indication anywhere in the record, anyone's deposition, that anybody used that exterior deck except Davis employees occasionally.
There was also testimony that JJML employers would use the deck
I'm
occasionally.
talking
as
about
well.
other tenants, though.
That's correct.
All right. So what is your argument is that demise premise is different than lease premises. The indemnification clause talks about lease premises. Lease premises aren't defined anywhere, but you say it's a fair reading of it. It's just everything inside.
That's correct, Judge. And even if there is a requirement for Elmer Davis to keep the demise premises in an orderly manner, that is superseded by the other provision of the contract or lease agreement that requires JJML to do all exterior maintenance. That provision of the contract
for the structural issues and siding issues and things like that, as opposed to a deck area that someone would be using.
that is not part of the contract. There's no qualifiers. That provision of the agreement for maintenance, all exterior maintenance, is not followed by all exterior maintenance except or all exterior maintenance but. It just says all exterior maintenance.
No, but it does say, and then there's a question of what supersedes what, because it's very specific talking about the demise premises being kept in a safe condition by the tenant.
Well, in that case, Your Honor, then it's our position that the terms of the lease are ambiguous and should be resolved in the favor of the non-drafting party, which is Elmer Davis. JJML prepared the lease agreement. They were in control of the language of the lease agreement. They could have put an express provision into this lease agreement that Elmer Davis was responsible for the maintenance of the deck, which a fair reading by someone who is not a trained attorney is that this Elmer Davis was not responsible for the maintenance of the deck because it is an exterior portion of the property.
Right. Or well, usually that principle, though, we construe against a drafter. Does that apply where you have two sophisticated commercial business operations here? They seem to be, it wasn't a consumer and a business. This were two businesses reaching an agreement on a contract.
I would argue that it does still apply that principle that if there's ambiguities of the contract, then it should be resolved in the favor of the non-drafting party.
Did the tenant have its own personal property stored outside on that deck area with like chairs and tables and things like that?
There's no evidence that Elmer Davis had any thing on that deck. There's evidence that the deck was seldom used and not frequented very often.
All right. So any other issues you want to be heard on?
Yes, Judge. There was an argument that was raised in the first time in JJML's reply in the appellate action that the lease agreement refers to incidents in or about the leased premises. I would just note again that that was raised on the first time in reply, and that on that part, there's an analogous case in the second department, Moore versus First Industrial LLP, and I'll just provide the citation. It's 296 AD 2D 537. In that case, the complaint in the main action alleged an action solely against the property owner based on the condition of a parking lot. And it was undisputed that the parking lot was solely the responsibility of the property owner. Now, in that case, the second department held that even though the lease agreement mentioned in or about the leased property, similar to the language in this case, that the property owner still had the duty to be.
Is that language in section 7A?
I'm sorry?
Is this in or about language you're talking about in section 7A, the indemnification clause?
Yes.
I don't see it there, but I'm sure it is. I just don't see it.
And like I was saying, that second department case ruled in favor of the tenant, saying that just because that language was in there, because the property owner had the exclusive responsibility for maintaining that parking lot, that the tenant did not owe indemnification in that case.
Thank you very much.
All right. If there are no other questions, I'll just rest on my briefings.
Thank you, Counsel.
Thank you.
Mr. Federation, you're here on behalf of JJML.
Correct, Your Honor. And just to answer your question that you just posed about the in or about language. So that's in paragraph 7A. It's the third line from the bottom. And it follows the word licensees. And that's the first word of the third line from the bottom.
Right,
So
thank you.
the in and about language does appear in that paragraph 7A.
But you disagree with him over the import of that phrase in or about? Or do you-
Absolutely.
Okay.
I think that phrase encompasses the argument that he's making in that it doesn't have to be within the office space. But in order even to get to that argument, we'd have to assume that there were two separate definitions of demise premises and lease premises, which there are not in the lease agreement.
Well, then why not use demise premises in the indemnification clause? Why even throw in lease premises?
I don't have a good explanation why they used a different word in that one paragraph, but if you look up the meaning of those two words, they are identical. And another point I wanted to make, just responding very quickly, that JJML was in exclusive control of the language of the contract. It's simply not true. If you look at the lease agreement, there are portions that are crossed out and initialed by the owner of Elmer Davis. They were negotiating the terms of this lease in an arm's length transaction between two commercial entities. It is the language of lease is not to be construed against my client. There was input from both sides. And there was a lot of discussion when Mr. Connor was up here about who had a duty to maintain the deck. And I can address that in a bit, but first, the lease agreement indemnity provision says arising out of the performance or the business and management conducted at the property. This court has defined or interpreted arising out of very broadly. In the case of Oliveri v. Barnes and Noble, that recent case from this court, defined arising out of as originating from, incident to, or having connection with. There is no doubt that this fall had a connection with Mr. Curran's, or I'm sorry, with Elmer Davis's business on the property. Mr. Curran was an employee who was at the property specifically for his employment, solely because of his employment. He went into their office and observed damage to the roof of their office. And he made the decision while he was in the lease premises to go out and look at the damage to the roof.
While it was in a driving rainstorm.
During a pouring rainstorm.
Would you agree that it's a different story if the accident occurred in a common area, parking lot, hallway, where other tenants had access to, then it's that provision doesn't apply, the indemnification provision?
I don't think it absolutely doesn't apply because there are two separate portions of that indemnity provision. There's the arising out of, and then there's the negligence of the employees of the tenant. So if it did occur in a common area, but it was still a result of the negligent acts of the employee of Elmer Davis, then the indemnity provision would still be triggered in my client's favor.
But this is not a common area in your view?
It's not a common area. It's behind closed doors. You need a key to get into their office, to walk through the kitchenette, which was part of that office space that are defined in the demise premises. And they were the only people using it were Elmer Davis employees. Mr. Connor mentioned that JJML employees would use the deck. And the testimony he's referring to was JJML used to use that same office as their office, but after they leased it to Elmer Davis, they no longer use the deck. That's what the testimony says.
You want to switch to the plaintiff's claims against your client?
Yes, Your Honor. And could I just make one more point on the indemnification, and then I'll move very briefly. So there was an argument made that my client can't maintain a culpable conduct affirmative defense and also maintain a third-party action. And that's simply not the case. The cases cited by Elmer Davis, every single one of them is referring to a common law indemnification claim. And looking at those cases, you'll see that not only is it just common law, but it's common law indemnification when the only negligence that the third-party plaintiff is passing down is the exact same negligence of the plaintiff himself. For example, the I can't pronounce it. I apologize. The Rosowski case. The plaintiff was the owner and sole employee of the third-party defendant. So anything that the third-party plaintiff would pass through, or any negligence they would pass through, would be the same negligence that's shaved off at the top through a culpable conduct offense. But that's not the case here, because there are independent acts of negligence of Elmer Davis, such as their failure to comply with the rules set forth in the lease for maintaining that deck. So I just wanted to touch on that and reiterate that my client's entitled to maintain both a contractual and a common law claim against Elmer Davis. And just getting to the motion in regards to the plaintiff's complaint. The first main point is this accident occurred during what the plaintiff described as a pouring rainstorm. I mean, everyone's heard the phrase slippery when wet. That applies to decks during pouring rainstorms. There had been no falls prior to this, whether the deck was wet or dry. There had been no complaints. No one observed any of the slippery conditions the plaintiff complained of.
In looking at your reply brief, you talk about how because of the pouring rain, that really we have to conclude that the slip was as a result of the water and not of any substance. But then we have Mr. Gardner's testimony about we have a plaintiff's testimony too, but focusing instead on Mr. Gardner's testimony, 529 of the brief, mossy, algae, slimy, it was like really slippery, like it was green oil. But then Mr. Courier's testimony, James Courier's testimony, 324, 325 of the brief. Do you know what that is? Looking at the photograph. I don't know if it's moss, but it's algae or something like that. Yeah. Some type of indicates like it's been growing in a wet spot. Yeah. I mean, so it seems that the record has sufficient support that there's a substance other than water.
I would agree with you that there's support that there was a substance other than water, but that doesn't mean that that substance was slippery, independent of the pouring rain that was happening during the accident.
Didn't the jury find, yeah, water slippery on the wood? It was a wood deck, I think. That's slippery enough that you throw algae or moss on there, it's even slippier. It's an added danger, increased risk here.
There's no evidence in the record to indicate that that's the case. I mean,
So you would suggest when people power wash a deck, they're doing it really just for the look of it, not for the ability to walk on.
If there's two rocks in a creek and one has moss on it and one doesn't, I'm stepping on the one that doesn't have moss on it.
That would probably be a wise decision, Your Honor, but we don't know what this green substance was. There's no actual evidence.
Why would you not step on the rock with the moss?
Because the moss would be slippery, but
Right.
I'm not saying that
If
moss
there's
is.
moss on this deck and it's raining, that's an increased danger of slipping, would it not be? If there was moss on the deck?
If there was moss, is there an increased danger of slipping?
Yeah.
I would say yes, there would be, but there's no evidence
Right,
that
okay.
there was moss.
I'm just trying to narrow what our differences are here. So Justice Nowak just read some testimony. People, they observe green slimy things and algae, whatever you want to call it. Is that, what do you think that was if it wasn't moss or algae?
I don't know what it was, and then there's no one who has testified in this case who knows what it was. There's been testimony that it was mildew, moss, algae, or microbial growth, and then also has been referred to as a green substance. No one actually knows what it is. And just to touch on the testimony that Judge Nowak previously mentioned, and that was Brian Gardner testifying after the accident while it was still pouring rain out. That's how his description during the pouring rainstorm of the deck. And I think all that is aside from this issue of constructive notice, and is that it had to be visible and apparent for a sufficient period of time before the accident happened that my client would have an opportunity to fix it.
What do you make of Jeff Martin's testimony? He used to work for Davis. He testified it was pretty typical for the deck to have leaves and some moss-like substance on it.
I think he testified that there was, in the fall when the leaves and sticks would fall, that there would be debris on the deck.
He said, quote, moss-like, well, I thought he used the word moss, but that could be I could be wrong on that, but he definitely said some debris. I'll give you that.
I don't believe he ever used the phrase moss like, Your Honor, and the debris, the leaves or the sticks, that's something completely different than what we're talking about here, which is something I pointed out in my brief too, is the plaintiff still hasn't really picked what their condition is. Is it the leaves and the sticks that were there, or is it something else? And Mr. Martin's testimony did refer to the leaves that fell from the trees every fall and then eventually would go away.
Do you have something in the record where the plaintiff says that he slipped on a stick?
No.
Or a leaf?
No.
Okay.
But the plaintiff's pleadings in this case and the opposition to motion and his brief in this appeal also mentions the leaves and the sticks and everything else.
Right. Yeah, I guess, I mean, on the summary judgment motion, of course, if the moving party has the initial burden of establishing as a matter of law entitlement to judgment, and at trial, they're going to have to prove it was the moss or the algae or some other slippery substance. On the summary judgment motion, though, if they're defending it, they don't have that initial burden, right?
It's exactly true. And the initial burden, this case is very, very similar. I'm not going to call it identical, but it's pretty close to the Decker v. Schlitt case of the third department, where the defendant there met their initial burden by submitting testimony that the defendant's own self-serving testimony that he used the stairs frequently. It was involved a fall on a green-like substance on stairs. The defendant testified he used the stairs regularly, never observed the green substance and never observed a slippery condition, and no one had ever fallen. And then that was enough in that case to shift the burden to the plaintiff to raise an issue of fact. And there, the plaintiff submitted evidence that they had fallen on some green substance on the stairs, and they submitted accident or post-accident photographs of the stairs that showed the green substance. The court there said this does not raise an issue of fact because it does not show that the green substance on the stairs was apparent and visible prior to the fall. And very similar here, the evidence is actually stronger. We had Elmer Davis employees using this on a daily basis for smoke breaks or work meetings. The plaintiff himself said,
sure about daily basis. But occasionally, my understanding is occasionally someone go out there and smoke. They didn't maybe have lunch. But in any event, do you want to be heard on the Section 200 claim, even if we were to rule against you on the negligence claim? Is this a labor law case at all?
I would like to be heard on that, Your Honor. And this is not a labor law case. My client is not a labor law defendant, and the plaintiff wasn't hired to do any work at the premises. The plaintiff was going out there on his own volition to look at the roof. He described for his own curiosity. In order for labor law 200 to apply, the plaintiff would have to be doing some sort of work at the premises.
So your argument isn't that it has to be a construction site, but you'd have to have something like, plaintiff were to call your client and say, hey, I think there's a problem with the roof. And your client would say, go outside and take a look at it. Then he doesn't even need a contract or an invoice, but that might be enough, but that's not what we have here.
Exactly, Judge. It could be some sort of maintenance, even if it was a factory and someone went to service a machine. I believe the one case cited towards the end of my reply brief was that situation. They were hired to go perform work at the site, and it was maintenance on a machine, and they had a slip and fall, and then that was enough to bring a 200 claim because the owner of the property had hired them. Just simply not the case here.
This is a premises liabilities case in your view, not a labor law case.
I view it as a premises liability case that should be dismissed.
Right, you think it's an unmeritorious premise liability case, but it has nothing to do with the labor law.
That's exactly right, Judge.
Okay, thank you very much.
Thank you.
Morning, Your Honors.
Good morning.
Sean Cooney on behalf of the plaintiff. I will be brief on the portions of the record that Your Honors asked Mr. Federation about, but I obviously believe that those portions of the record constitute evidence of an unsafe condition and certainly evidence of constructive notice, which I'm entitled to every favorable inference therefrom, which makes this motion required to be denied because they don't meet their burden. What I also want to talk about is even if they did meet their burden by suggesting that there was solely the rainwater as the cause. I did raise a question of fact as a result of supplying the photograph, that there's testimony that there's a skid mark from his foot in green substance, not water. An expert, their arguments against my expert go to the weight, not to the admissibility.
And for constructive notice, is there any, assuming they met their initial burden, it has to be there visible and apparent for a sufficient period of time. What evidence do you have that it was there long enough so that the landlord could have seen it and corrected it?
There's several responses to that, Your Honor. First of all, Mr. Martin's testimony, as you mentioned, indicated that that is the picture of the deck, is what the deck typically looked like. And that was an accumulation of debris, leaves, sticks, other things, which resulted, and this is the distinction, resulted in the growth of some substance, some foreign substance. So we have Mr.
How would the landlord, this is part of the demise premises exclusively used by Davis. How would the landlord even be on that deck? It's a raised deck. How would they be in a position to know about the mold?
Of course, it's established law that constructive notice includes a duty to inspect. In this particular case, the way the landlord maintained the property was through an employee named Peter Courier. Peter Courier actually built the deck. He'd been on the deck in prior times. He testified if my father, Jim Courier, had asked me to go on the deck, I would have done so. He didn't ask him.
So the landlord in this situation is supposed to go in with his or own keys or have somebody do it and just inspect inside, go through the kitchen, go through the bathrooms, go through the meeting rooms, go to this attached deck and look around for dangerous conditions.
Or just seasonally maintain his property consistent with the terms of the lease that gives them the right to enter the property upon notice. Everyone at Elmer Davis testified they never denied access. They certainly would make those accommodations. This is obviously reasonable conduct for any commercial landlord. You can't ignore portions of your property. And even if they say that it was somehow Elmer Davis's responsibility, they can't just assume that it's happening. That's not what the law allows them to do. They still have an obligation for reasonable inspection, at least at the stage of summary judgment. They could argue, as you just said to the jury, that it wasn't unreasonable to let Elmer Davis do those things, but that doesn't eliminate their duty to do it under the law.
Who had the obligation, the landlord or the tenant under the lease, to clean and maintain the demise premises?
They both say the other one did, which is probably why it didn't happen, and probably why there was an accumulation of this foreign substance, which resulted in the fall.
Well, if it were inside the office, then it was on the tenant exclusively, right, under the lease?
The only portion that's excluded, I think, is exterior. So yes, but I'm not taking a position on the identification, obviously. But I do think if it was inside, although those aren't the facts, if it was inside, it would be on the tenant.
Okay. Let me heard on the section 20. How does this come within the ambit of section 20 of the labor law? If you went on the common law negligence, it's really kind of irrelevant, but why should we keep that cause of action alive here?
The owner of the property and the employer are in privity through a lease. Labor Law 200 applies to manufacturing settings, applies to a lot of non-construction settings. If the notion that an owner of a property has to actually hire the employee and supervise and direct and control, you would always have a workers' comp bar. You would never have a statutory liability on an owner for an unsafe condition on their property.
Was he doing covered work at the time?
If we're not sure whether or not Mr. Curran is a covered work under Labor Law 200, this isn't 240 and 241.6. It's a much higher, different standard. But if the best argument to understand that is Mr. Federation's argument on whether or not this arises out of Elmer Davis's work. Mr. Federation told your honors that Mr. Curran's work was undoubtedly through his work with Elmer Davis. Elmer Davis is a union roofing company who's there with privity with the employer. What he's doing is, as Mr. Federation said, it's definitely consistent with his job as an Elmer Davis forum.
Well, they're a roofing company, but they didn't get hired to do the roof here. What if Davis was a law firm and somebody walks in, the first one in the office in the morning, sees water coming through the roof, says, well, let me go out onto the deck to look, as your client did. Is there a leak there? And he falls.
I hope
that a section 200?
I hope that every one of my employees, if they get to my law firm before I arrive and there's water pouring in through the roof, that they walk outside to see if there's anything they can do to stop it.
But does it make it a labor? Does it make it a?
And I would consider that them doing exactly the work that I hired them to do, to be in the office. And if I wasn't a law firm doing office desk work, but I was a union roofing company with a warehouse and a union foreman in where I assigned him to go, yes, that would be labor law 200 without question. To say that the owner in labor law 200 has to actually make each employee do their specific task would eliminate the labor law statutory obligation on owners. What 200 doesn't apply to situations where we are fully removed from this type of workman type task. It applies to people working in shipping. It applies to people working in manufacturing.
But that's not Justice Lumley's question. Justice Lumley specifically asked you if a tenant, and he used the law firm as an example, does a commercial tenant get covered under labor law 200 if he falls because he's inspecting a defect in a property?
Yes, I believe he does. And when I bring up manufacturing and shipping, what I mean is that the owner of the manufacturing facility is the labor law 200 defendant, not the company that hired them to build whatever they're manufacturing or the end product. The statute puts the obligation on the owner of the property. Their control is vested by virtue of the ownership. So a manufacturer who's in privity with an owner, that owner has a statutory obligation to provide a safe workplace.
I mean, it was ironic, to say at the least, that your client worked for a roofing company and this accident was caused by a leak in a roof.
They should have hired him the summer before. I don't know. It's the no good deed goes unpunished. Union roofer goes to work at 6 a.m. There's water pouring in to the facility his employer rents. He tries to figure out what's going on to see if he needs to stop it, and he falls and gets hurt. And I think that is definitely what you would expect someone in his position to do. And that's why he's entitled to the protection, the statutory protection that an owner is required to provide a safe place to work.
All right. And finally, you don't have a dog in the fight between the indemnification, between the other, you just want to get paid. You don't care who pays you.
I don't care who pays me. No, Your Honor. One last quick thing, the argument about the property maintenance codes providing a general, not specific statutory command was raised for the first time in reply. And the authority provided in that reply deals with elevator standards in New York City Administrative Code. So in the event you reach that, I don't think you should, but in the event you reach that, I don't think they have a general command.
Thank you, Mr. Kuhn. We'll move on to case 496 is Hunt versus Matthews. Case 496. Mr. Myers, good morning to you.
Good morning to the court. I'm Jim Myers, and I represent Laura Matthews, who is a senior citizen and who was in August of 2022 engaged a real estate company to list her home and made it very explicit to the company that she demanded and required that there be a reverse contingency clause.
Right, but that wasn't, that demand wasn't put into the contract until after she signed it, right?
That's correct, Your Honor.
And so really the issue, and it's, haven't seen this issue before, but for the approval letter, for your client's approval letter from the lawyer.
Yes.
Your lawyer signed the approval letter on September 2nd.
That's correct.
And the client is saying, I never told him, I never gave him authorization to approve the contract.
That's correct.
And therefore his approval is without legal effect.
That's correct.
She did sign the contract though.
Yes.
And agreed to all the terms and conditions,
right? Well, she didn't read every single word of the 13-page document, single space. But the reason the attorney contingency clause is in there is to provide the attorney and her client an opportunity to review the contract together so that it can be approved or disapproved.
But the approval does not require her written approval. It only requires the attorney's approval.
No, but it does require.
Wait a minute, the answer is yes.
I'm sorry.
No, right. I mean,
yes.
I think we're mixing each other up.
Yes.
So you're going to go on in your answer, but it does. There is no space or anything that requires Correct. I just want to make sure we're on the same page on that.
Yes.
Okay, go ahead. I'm sorry.
Yes, yes, but the legal obligation of the lawyer is absolutely clear. And I cited it in the brief in terms of the professional responsibility and duty that the lawyer can only act within the scope of whatever his client has permitted him to do so.
You brought an action against the attorney, correct?
Yes,
All right. I mean, now you got a contract that's been signed and approved by both attorneys within the prescribed time period. You have a contract.
yes,
You have an agreement. There's no doubt that Mr. Weir was your client's attorney, correct?
that is correct.
At the time that he signed that approval letter.
That's correct. That's correct.
Would you agree? It appears to me that your client signed the contract, realized it didn't include an important provision after her attorney approved it. It's like, wait a minute, I want to be able to live there unless and until I can find a suitable replacement house. That was, she changed her mind or she realized that it wasn't included in the contracts he signed, right? That's what happened here.
No. She did not realize he ever approved the contract.
Well, then
the first time that
she signed the contract if it didn't have that provision that allowed her to stay till she found another house? She signed the contract.
Well, with the attorney approval letter is exactly so that the client and the lawyer would have the opportunity to review the contract and for the client to say, yeah, this is what I agreed to. The only time she ever, I'm sorry, Your Honor.
Go ahead, finish.
No, I mean, the only time that she realized that the attorney approved the contract was when she personally met with him on September 8th. Prior to that, she had no knowledge whatsoever that there was any approval.
So is this approval supposed to be in writing from the client to the lawyer? Like, I hereby authorize you to approve this real estate contract on my behalf, or telephone communication, or email, or how is that? That's a legal requirement, you say, for the validity of an attorney approval letter.
The attorney is not authorized in any real estate transaction. If an attorney is going to act on behalf of the client, the attorney is obligated to have the client's consent. I mean, here you have a very detailed contract, 13 pages, and you also have an addendum because this is a little more involved than that. The question is, what was being approved here? Now, the contract itself specifically requires, if there's any addendum to the contract, that it must be approved by the attorney. There's no ifs about that. And in that contract itself, it never referred to the addendum that the parties signed.
I guess what the argument is that.
What?
I guess the argument is that the addendum then might not be enforceable, but the body of the contract would be.
I think it goes a little further than that. The question is, does the contract embody the agreement of the parties? Now, the contract and the addendum was signed at the exact same time, but neither lawyer ever approved the addendum. There's no indication that the lawyers even knew of that addendum, even though that addendum said.
Well, they would have had the contract in front of them at the time. They signed the approval letter. Are you arguing they did not even have the contract in front of them?
No, I'm arguing they may not have the addendum that was signed.
The addendum was attached to the contract.
How do we know? How do you possibly know? Because the contract itself.
And that's the addendum that your client signed saying that I can live in the property for another 6 months after December 1st at a cost of $2,000 plus utilities, right?
That's correct.
Is that a contract? Is that a provision that a layperson would not understand?
The question here.
That's my question.
What?
That's my question to you.
To my question. No. In this case, this client wanted a provision in there.
But didn't your client also get an initial $10,000 to waive that?
No.
There's an affidavit from the realtor indicating that if you look at the ML listing, the listing is $349,600, whatever it might be. And in order to get up to $360,000, which is the additional, the actual price of the contract that was signed by your client, was another $10,400, which she agreed to waive that reverse contingency. Isn't that correct? Isn't there an affidavit that says that?
There is an affidavit.
Right.
There is an affidavit.
Are you disputing that the MSL listing price was $349,600?
No.
No, and then he just, the contract price was $360,000.
Yes.
Correct. All right, so she got an extra $10,400 that the buyer then.
We don't know. She did not understand, and there was no way that she could understand. But again, Your Honor, by the terms of the contract.
It kind of sounds like your action then is against Mr. Weir, what you've done. He didn't fulfill his obligations to me as his client to talk to me about this, sit down with me, review this with me, or at least talk to me on the phone about this. He didn't do that. I brought an action against him. I still have a contract with Mr. Hunt.
Number one, the addendum was never approved. If you're going by the terms of that contract.
If you don't approve it, then it's part of it. You didn't make reference to it. It's part of the contract.
But it was the understanding of the parties that the addendum was to be a party of it. And if Mr. Weir had the addendum and sat down with my client, which occurred on September 8th, he then realized that contract was not going to be acceptable to my client.
Does it have to be a sit down, or can Ms. Matthews here just call the attorney and say, can you look at the contract and see if it's okay? And then approve it on my behalf if you think it's okay. Is that okay, just to make a phone call? Or does the lawyer to approve the contract have to sit down with the client and go through each and every provision?
I think the lawyer has to have a conversation with the client in the first place and say, I have this contract in front of me. First of all, do you have any questions? Or before the lawyer sends out the letter? You just don't send out a letter as a lawyer approving a contract without the knowledge and consent of the lawyer. And then it gets even worse than that, because we have pled and we have shown that Mr. Weir's office, his assistant attorney wrote to her and said, we don't give copies of attorney approval letters to the client. That's not how one practices law. You know, you at least copy the client on it.
But isn't that for the action against the attorney?
Well, we do have the action now, right now we do have it, but again, it goes to whether or not the attorney had the authority. And this attorney never had the authority.
Yeah, I think, well, you make some interesting, I've never seen this argument before, but I think it might be implicit if you hire an attorney to review a contract and approve it as to form, for the lawyer to go through and make sure that there's nothing in there to be harmful to you. But if we agree with you, could not a buyer or a seller just unilaterally get out of any contract at any time? For example, you sell me a property, we sign the contracts.
Well,
Judge Montour is my lawyer. I say, he approves it as to form. 3 weeks, 5 weeks later, I say, I want to buy another house, or I got another offer that's higher. And I say, I never authorized him to approve it. We're done here.
Yeah, but what happened here is that within the 3-day period, it is undisputed, within that 3-day period, she got into the office, and the moment she got into the office, Mr. Weir sent the letter saying, I'm giving you a revised approval, and this revised approval is contingent upon her finding suitable housing. That's within the 3 days. That's absolute. And the Court of Appeals in Moran versus Irk talks about that. And in this contract itself, it says within the approval period, you can disapprove it. It says right there, if either party disapproves the contract before the end of the approval period, this contract is deemed canceled.
Didn't have. 3 days. It was approved on September 2nd.
No, but you had Labor Day, you had the holidays. The record is clear. The other side concedes. The other side concedes that you had till September 8th to.
But the approval was already given.
Without authority. There is no.
Again, that attorney is an agent of your client, and the action is against your attorney as far as that's concerned. Right now, you have a situation where you have a contract, the lower court has ruled that there's a contract, lower court has ruled that your client violated or breached that contract, and they also award a specific performance. But it's been 3 years since, and your client's still residing.
Well, look, first of all, they have not even put in a brief in regards to it. And as a matter of public record.
Is this even,
it matters,
your client still lives there, right?
Mr. Hunt.
We haven't heard from Mr. Hunt. For all we know, Mr. Hunt bought another house and he's happy as a clam.
Yes.
So
that's what's happened.
Do you have a legitimate fear that if we affirm Mr. Hunt is going to be moving in anytime soon?
Yes. We have a fear she's going to be put on the street and she has no place. She doesn't have the resources to buy a suitable housing.
But Hunt didn't even reply to this appeal.
What?
Mr. Hunt didn't apply to respond to this appeal. And have you heard from his attorney?
Well,
as of late, they still want specific performance. Hunt does.
Yeah. Even though.
Have you heard that from him or no?
No, we have a public document that Mr. Hunt bought another condominium in that same unit, in the same place on October 23rd this past year, which may be the reason that he has not submitted this.
So do you think he wants this property for a rental property?
I have no idea what he wants.
So bottom line is you have no idea if this is moot or not. You have no idea if Mr. Hunt still wants to pursue this on specific performance. Maybe he just wants some monetary damages. But either way, if your legal claims are correct, you're entitled to some relief here, and we're going to take a good long look at those. And we appreciate your arguments today.
Can I just, as a matter of public record, give you the deed that was recorded on October 23rd, 2024?
This just shows he bought another condo in the same unit?
Yes.
How does that help you here? It sounds like he may have found another one and he's good. He may not want this one anymore.
But he, again, I represent a person who has extremely limited resources. And why should she be punished? Because her attorney didn't do what he was responsible to do.
To be fair, she signed a contract that did not have the provision that she later wanted, which said, this is contingent on me finding a suitable replacement house. That got put in after she signed it, after her lawyer approved it. So there should have been, if she had read it more carefully, that should have been in the main contract.
I've practiced law for over 55 years. I've rarely seen a client who have read every single line of this 13-page document. That's unrealistic.
And that's why they're hiring an attorney to do it.
That's right. And that's right.
Mr. Ware is an experienced real estate attorney.
That is absolutely correct.
He's read that 13-page contract.
Yes.
How's he supposed to know that she wants this new provision?
What?
How is he supposed to know that?
Because a real estate broker should have told him. Because in the listing agreement itself, it says she requires this. So that should have been made available to Mr. Weird at that time. She went in there August 22nd. She doesn't have the funds. You can't, I submit you throw out on the street is a grave injustice for somebody.
Throw her out in the street with 360 grand?
No, she has a mortgage. She has a good sized mortgage. She is not a wealthy person.
All right.
I mean,
we will look very carefully at all of your arguments as we always do. Anything further? You look like you're.
Well, no, I would like you to consider in terms of the motion to re-argue and the motion to renew, because there is additional documentation in the motion to for leave to appeal that sets forth what occurred in her conversations with her attorney. And this, I believe, is relevant. It's meaningful, and she is being punished for what her attorney has failed to do. And we as lawyers have an obligation, I think, to go to a higher standard than what occurred.
Where's that
here.
lawsuit, by the way? For lawsuit against Mr. Weir?
Yes.
Where's that in the legal proceeding?
It's just in the discovery phase right now.
Thank you very much. Appreciate it. We will move on to case number 498, Parsons versus County of Steuben. We are, Mr. Fitch here, Mr. Special are in the courtroom. Appellant's counsel is remote. We may proceed.
May I please the court, Tony Martosha for the plaintiff appellant. I just want to briefly address the labor law 240 issues. If you look at the case law coming out of this court over the last few years, it's unquestioned that the facts of this case warrant summary judgment on the issue of labor law 240. Specifically, I'm talking about the specific cases that I'm referring to are vetted in my brief. Specifically, it's Vasquez v. Gilbane.
Vasquez, this is it's a good panel for you on Vasquez because Judge Nowak was the trial judge. I was on the appeal. Justice Greenwood and Justice Monto were on the appeal. So doesn't mean we're going to agree with you on that.
Well, I thank you for the decision.
We know the facts. You can spare us the facts. But so in that case, there was a ladder that was vibrating due to something being done, and then it fell. This was not a vibrating work site. The ladder just fell. Somebody slipped on ice, or the ladder slipped on ice. So it's a little different factually. Does that make a difference?
No, I don't think so. The question there was whether or not a ladder falling onto a plaintiff needed to be secured. And I think obviously the court answered that it did need to be secured. It's a similar case was the Vicky case, I believe it was, where they were actually extending the ladder up and trying to place it. In both of those cases, those are two ladder cases where the court held it required to be secured. So I don't really see a big difference from putting the ladder up as opposed to taking it down.
Well, how do you secure a ladder? If you're supposed to take it down, don't you have to unsecure it?
Well, there was testimony that it was secured from the top and in the middle. And there was testimony that in order to take it down, they needed to unsecure it from the top and the middle. I don't see why they couldn't have secured it, at chest height, and then slid the ladder down.
Counsel, I saw that argument in your brief. The only concern I have is I didn't see it in the expert report.
Okay.
So in the brief, and it made sense just from my very limited knowledge of extension ladders. I didn't get to inspect this one, but generally the part that slides down is the part is on the inside. And so if you were to strap the outside at the bottom, you could theoretically still move it down. I don't know whether you could or not, but I would look to the expert and say, if the expert were to say, oh no, what you do is you strap it, 5 feet up off the ground. And that way, at least it's more stable. Once you finally remove it from the pole, I mean, it's got to be unstrapped for that, obviously, but it's easier to do that once it's in the collapse state. So it's not 40 feet, it's 20 feet or whatever the collapse length ends up, 20 feet, whatever it is. I didn't see it in the expert report.
Yeah, it was.
Now I don't know if that's enough for us to go on.
Yeah, I just don't know that it's my burden. It's not my burden to prove that it's impossible. I think that would be the defense's burden to prove that it's impossible to lower the ladder absent, without using a safety device. I think it's their burden, not mine. I think common sense, like you said, common sense tells me you could have tied this thing around at chest height or even lower and prevented it from falling.
Well, but we have testimony in the record that you couldn't have it secured and still, finish collapsing it and removing it. We have that from several witnesses.
Well, I don't know if that's exactly what the testimony was. The testimony was that they had it secured up top and they had it secured halfway down. And then they had to remove that in order to lower the ladder. And what defense counsel did is they took that a step further and said they had to have this thing. There's no way you could have secured this ladder to that pole. And that's not what they testified to. What they testified to was in order to get it down from its current position, they had to undo the two straps up top. There was no testimony that they couldn't have strapped it lower.
Would you agree that at some point the straps had to come off this ladder, right? They got to put it back in the truck.
Correct.
So they took the two off. You suggest they should have had one lower.
Yeah, if they
Strap
had one
lower to the pole, but the lower strap's got to come off too, right?
Sure. Right.
So if this accident occurred, let's say they used a lower strap. They take the lower strap off because they got to detach it from the pole. They're going to carry it to the truck. If the worker slips then on the ice and the ladder falls and it strikes your client in the head, then is that a falling object case? Of Labor Law 240(1)?
I would think so. If it's not secured properly and it falls,
what safety device would have prevented this? How do you get a ladder down, an extension ladder down and into the truck? What other safety device could have been used here?
Yeah, whether or not, I don't know, but it's certainly not the facts of this case. At the point where, because if anybody's lowered a 40-foot ladder, and I assume that you have, it's difficult to get it down, and that's when it's the most unstable. So my thought would be that until they get it down to the ground and collapse that ladder, at that point, maybe they could take the straps off. But that's not our facts here. Our facts are that, in the process of lowering it. But even then, I don't know. My thought would be if it falls, it was unsecured or wasn't secured properly.
Counsel, when you argued this case below, did you also move for partial summary judgment on liability under 241(6)? Because we have, it seems, uncontroverted testimony that the slipping on ice, the ladder, the feet of the worker, or both, that the slipping on ice contributed to this ladder falling. And they're on this, they're next to the pole on this sort of crushed stone area that had some snow and ice accumulated, and some of the snow was removed, but it was still slippery. Was that part of your motion below?
I believe it was, and I think what the judge did there was said that it wasn't ripe for a decision at this point. That further discovery for some reason needed to be had, and that there were depositions since that time.
Right, but you didn't bring it up on your appeal, correct? I mean, you're not asking us to grant you summary judgment on 241(6).
I don't believe so, Your Honor.
I'm sure you wouldn't object.
You're asking that be reinstated, correct?
Yeah, I think at that point, the judge said it wasn't right. I don't think it'd be right for an appeal because the judge said at this point that it wasn't.
So
that there needed to be additional discovery.
And you agree with that?
Is discovery?
Not necessarily, Your Honor. It's clearly that there was ice. It's a clear violation of the 241(6).
Your summary judgment motion below was not, it was based solely on 240(1). Right?
Okay.
I could be wrong. I think your motion was based on 240(1). The other side, the other side moved to dismiss the 241(6). You oppose that. And then now on appeal, you want summary judgment on 240(1). You don't ask us for summary judgment on 241(6). Do I miss anything there?
No, my apologies. You're right. You're correct, Your Honor.
But you did cite that recent Court of Appeals case, Bazarick, well, recent being 2024, that seems to be a good case for you on your passageway. That one regulation, I think it's 22 NYCR 23-17 or something, that talks about the employer must keep free all walkways and passageways and other elevated work sites, free of ice, snow, and other foreign contaminants. This Bazarick case is going to help you on that, but you're not You're not asking us to give you judgment as a matter of law that here today, are you?
Doesn't appear so, Your Honor.
You wouldn't be terribly disappointed if we did.
Yeah, exactly, Your Honor. I'm not sure if the court can do that, but heck, yeah, no doubt about that.
All right, so your main argument is getting judgment on 240(1), defending dismissal on the others. Do you have some other arguments you want to make with respect to defending the defendant's motions to dismiss here, certain causes of action?
No, Your Honor. I'll rest on my papers.
Thank you. Ms. Scarmato?
Good afternoon, Your Honors. Gabriela Scarmato on behalf of Motorola Solutions, Inc., defendant, third-party plaintiff, and respondent appellant here. With respect to plaintiff's arguments regarding Labor Law 241, it is my position that the Vasquez versus Gilbane case is slightly different here. That case involved an unsecured ladder that tipped over. Here we had a secured ladder that was in the process of being dismantled. So for the purposes of the undertaking at the time of the accident, it did not need to be secured. Same similarities were found in the Vicky versus City of Niagara case. And for that reason, the lower court correctly dismissed the Labor Law 240 case. Turning to the 241 case and plaintiff's arguments that I know he's not moving for them, but in our underlying papers, we did move for the dismissal. The lower court found issue of fact. He did not deem them not ripe for determination based on outstanding discovery. Note of issue was filed, discovery was completed. Plaintiff did not specifically plead any violations to the industrial code until his opposition papers to our summary judgment motion. In those, he moved only for violations of 1.7D and 1.21B42. So to the extent that he's now raised additional industrial code violations on appeal, we would argue that it's not appropriate for determination.
How is there not an issue of fact on 23(1-7D based on that recent Court of Appeals case?
So it not being applicable in that it did not occur in any of the enumerated areas, specifically a passageway, walkway, scaffold, platform, any of those areas. The pole where the work was being performed and occurred on an embankment. Even if this court did find that there was some sort of that applicability here, would be our position that Motorola did not violate that section. Midstate was responsible and in fact did. There's testimony that they removed the ice and the snow prior to installing the ladder and then secured it. And so no.
You would acknowledge there's at least an issue of fact of whether the ice was still there or snow was still there, because either the ladder slipped on it, which seems a little unlikely, or one of the two workers slipped, more likely. So there was some ice there, at least an issue of fact.
I could understand a finding of an issue of fact in that regard. I would argue that there's testimony the snow was removed prior to its installment. It was used for 3 days prior to the accident without any issue, without any slipping or complaints made to anyone regarding a slippery condition being present while the ladder was erected. Nothing in relation to my client having any sort of notice creating or not creating a slippery condition.
I don't know if you need notice on the 241-6, but was this a walkway or a passageway?
It was not. The testimony we have is that it was on a crushed gravel pad in an embankment. There is cases I've cited in my brief that have held that because it's not an enumerated area under 1.7D, that violation does not apply.
You would agree that that section doesn't talk about escalators either, and yet we have the Court of Appeals in the Bedzar case saying that it clearly applies.
I do understand the case that you're talking about. I believe that case did find it was an enumerated area relative to one of the items that are listed in that section. I don't recall if it was a walkway or an elevated work surface or an elevated surface, just it being an escalator going down. But this particular area did not encompass any of the enumerated areas under 1.7D.
This is a surface that stone was added. This is before snowfall, of course. that stone was added to build it up to make it level so that you could put ladders there against the pole and workers could work there if necessary. It was put in place exactly for this, right?
I don't believe so. I believe it was an area that existed already and they were just securing the ladder on kind of a hilltop. I don't believe it was something that was created specifically for this, as my understanding.
Your understanding is that there was a slope there. So if you went from one pole to the other side, it would be much higher than on the one side. That's your understanding?
It was on it. The area was on it. The way it was described, that the area was a hill. The pole was located on a crushed gravel pad and an embankment. That's the description that was given in the record.
Right. My understanding of that Belzer case is that the issue there was the foreign substance issue, whether the plastic that they put on that escalator was that a foreign substance or was it part of the work site? It seemed to be, though, consistent with Justice Nowak is saying, is that it seemed to be taken as a matter of concession that it was an elevated work site, a platform, a walkway, or a passageway. Again, that issue really was at the forefront of that decision. And but I guess your overarching concern is if the plaintiff had moved on this ground, these could have been fleshed out and we could have had a more record below.
Correct. He did not cite them until his opposition papers, and even now kind of glossed over them on his reply brief. Same would apply to section 1.21B42, which required the ladder footings to be firm. I would argue similarly to 1.7D that there were spikes in the bottom of the ladder before it was installed. Any slippery surfaces was removed by Midstate. Stayed there for 3 days without any problems, without any complaints of slippery surfaces. And so not only does it not apply here, but it was not violated by Motorola. Briefly,
anything further?
I'm sorry?
Anything further on the remaining claims?
I would just like to note that it seems as though the Labor Law 200 and common law negligence claims were not pursued on or addressed in plaintiff's reply brief to us, as he directed them solely towards Steuben County. So I'll rest on my papers with that. And lastly, I just do want to note that the underlying decision by the trial court did not make any mention as to the contractual indemnification or any of the other third-party claims that were asserted against Midstate. And I will mostly rely on my brief for that, but would note that the Masciota versus Morse Diesel International Inc. Is on point in this case with a similar indemnification language and a finding that indemnification did apply because the defendant in that case had no active negligence. The ladder was not owned or supplied by the defendant, wasn't set up by them, no supervision or control, no notice. And so indemnification is appropriate here. And I'll rely on that.
Thank you.
Thank you.
Thank you, Counsel. Mr. Fitch.
Good afternoon. May it please the court. David Fitch on behalf of the County of Steuben. As indicated in our submissions, we asked the court to affirm the trial court's decision to dismiss the Labor Law 241 claim and to reverse on the lower court's decision on the two other causes of action brought by the plaintiff.
When you say 241, you mean 240 sub 1 or 241-6?
240 sub 1, Your Honor.
Okay, thank you.
And as it relates to the Labor Law 200 claim, I would just reiterate, as indicated in our papers, that the county did not create any alleged hazardous condition and certainly did not supervise, direct, or control the work done by the plaintiff and his coworkers. Furthermore, regarding the claim of 241 sub 6, as we indicate in our papers, the 1.7 alleged violation, I would just reiterate that the plaintiff and his coworkers were charged with removing any ice or snow and had done so previous to the alleged incident in this matter. Furthermore, the 1.21 alleged violation. The plaintiff was not in the process of any construction or excavation work at the time. As indicated in our submissions, he was cleaning up for the day. There was nobody on the ladder at the time. Nobody was using the ladder at the time. His coworkers were taking the ladder down.
Does the case law support that type of reading, that we do it that narrowly, that you look at exactly what they're doing at the moment they're hurt as opposed to the overall project?
Yes, the county would submit, Your Honor, that the specific circumstances leading up to the incident are at least considered. As far as there was no elevated work being done at the time of the incident as it relates to 240 sub 1. As far as the county's position, it did not create the alleged icy condition. It did not control or supervise the plaintiff or his coworkers leading up to the incident.
Well, let's say Mr. Parsons were taking a break. He's on lunch, he's just sitting there eating a sandwich. And an object falls from an elevated work site, falling object, and hits him. Your argument seems to be Mr. Parsons here, his work was done for the day. He was just cleaning up, getting ready to go. So therefore, he's not a covered worker. In my hypothetical, he gets hit by a falling object because he's not actually engaged in construction or alteration at that particular moment. He's not covered.
If that occurred from an elevated work site, then it may be covered, Your Honor.
Because that's what
regardless of what
they're saying. This ladder was a falling object because it fell on him. Now I know we disagree with that. I know you do.
Yes,
I should say not we, but you. But the timing is just as Noack said. The fact that he was just cleaning up as opposed to actually doing his work. I don't know if that's supported, but do you view this as a means and manner case or a defective condition case?
I would note that the plaintiff does not allege that there was a defective condition.
The ice on the ground was.
Well, as far as certainly related to the ladder, the plaintiff alleging that there was ice there, certainly as indicated in our papers related to the industrial code allegations, it was the plaintiff and his coworkers himself responsible for cleaning off any snow or ice at that location.
Well, they say that your client, as the Oviant, as the owner of the servient easement, had a non-delegable duty as well.
My client would disagree with that, Your Honor. That as part of, as the testimony indicates from the only county employee who was on site ever, that the plaintiff and his employer were responsible for cleaning off snow or ice around the ladder. At no time did the county ever do that prior to this incident. At no time did the county do anything else regarding cleaning up or cleaning an area off.
I think that's what plaintiff thinks the problem is here, but we will take a look at that. Is there any other arguments you want to raise that are outside that you?
Not at this time. I'd rest on our submissions. Thank you.
Thank you.
Good morning, Your Honors. James Special for Mid-State. So I don't want to beat a dead horse here, so I'll try to be brief. But so as far as the 240 sub 1, he's taking it down. And one thing I was going to say that Justice Nowak brought up that struck me too was the affidavit from the expert, because he doesn't actually say what was supposed to be used to secure this thing while they were taking it down. Because, I mean, it's all just guessing. Oh, well, maybe he could have used this, maybe he could have used that, but it has to come off the pole at some point, right? So it can't really be secured. And my recollection from Vicky, and don't quote me, because I could be wrong, but I when I looked at that case, there's a portion that I think is actually good for me, because there's a note in there, And it says something like, well, it's not like the falling object was meant to come down or something like that. So that's
Yeah, it wasn't being hoisted here. The ladder wasn't being
right,
hoisted.
right.
It was.
It was meant to come down.
Yeah, you're not, how are you to secure a ladder? You have to take it down. You have to unsecure it. I guess is their argument.
Sure.
Your argument.
Right, right.
That you can't have a safety device that holds up a ladder when you got to get into the truck at some
Wait.
point.
Right.
I have a couple of questions and
Okay.
bear with me, which is a ladder, 40-foot ladder. And forgive me, I do not know anything about ladders. Okay. So it collapses to 20 feet then? Is that, it like collapses in half? I understand that I might be asking you something that's.
Yeah, I believe that's usually how it works. Yeah.
Okay. And then it folds inside of the outer part of the ladder,
Yeah.
is my understanding.
Yeah.
Okay, thank you.
This one, when it fell, was it still extended to 40?
I think if my recollection is right, I think it was partially down.
And then the plaintiff was working somewhere else and it just happened to
Right.
hit a fence and then
Yeah.
ricochet onto his shoulder and head.
Yeah, that's basically, you have that right. But yeah, just the fact that it was it had to be taken off the poles, and that to me just separates it from any type of case where the ladder was meant to be secured. It wasn't. I mean, it wasn't meant to be here because it wasn't being hoisted or anything. They were taking it down. So that's why I think that the 240 sub 1 was properly dismissed. Now, as far as the 241 sub 6 issue, one thing that we note on page 28 into 29 of our brief was that it seems to be what your honors are interested in is 1.7D. There was no mention of that in the complaint or the bill of
I
particulars.
think it was in the bill of particulars.
Was it?
Yeah, no, they didn't say,
Because
they didn't go on to the other subsections. My understanding is that they did say 22 NYCR 23-1.7. They left it at that. They didn't get to the D2 whatever, right?
oh, fair, okay.
I don't know, could have been a little more through a few more numbers or letters on there, but
Yeah, well, we just might disagree about what is sufficient there, but fair enough. So other than,
but you won on that. Well, you wanted that one dismissed.
we did, and we
You
did,
still want it dismissed, okay?
yeah. So I would, in light of what your honor just said, I would just suggest that what was in the bill of particulars wasn't sufficient. And I mean, other than that, I think we covered the other parties did a fairly good job of discussing all the issues here. So unless there are no questions, I can rest.
Thank you very much.
Thank you.
All right, number 499, the Genesee County versus State of New York. Rocco, good morning.
Good, Judge.
Good afternoon, yes, it's your afternoon. We have Mr. Palladino who is joining us from his office. Mr. Palladino, you may proceed.
Good afternoon, Your Honors. When the legislature and the governor in 2023 enacted a law that reconfigured the board of directors of the Western Regional Off-Track Betting Corporation, they were not required to follow the home rule provisions of Article 9 of the New York Constitution. And this is so for two reasons. I mean, first, those home rule provisions only apply when the legislature acts in relation to the property, affairs, or government of a local government. But here the law regulates the board of directors of an off-track betting corporation, which is not a local government, is a public benefit corporation. So that renders the home rule provisions inapplicable. But even
It does have would you agree it does have an effect on these counties? in these plaintiff counties? Because their votes are diluted. Now they used to have one county, one vote. Now they can be outnumbered if you have Erie County, Buffalo, and either Rochester or Monroe. Those latter four to do whatever they want here on this board.
Oh, yes, I readily acknowledge that the local governments have an interest in the operation of the off-track betting corporation, but so too does the state. And the fact that the state has a significant state interest in the operation of this entity is a separate reason for rendering the home rule provisions inapplicable. I mean, this corporation is part of the legislature's implementation of the gambling provisions of Article 1, Section 9 of the New York Constitution. That shows that the state has a substantial interest in the OTB's operation. It also collects revenue from this entity. This entity also distributes many millions of dollars, not just to one local government, but among 15 different counties and the cities of Rochester and Buffalo. All of that gives the state a substantial state interest to act here. And there are at least two state interests that are at play here. The first one was that there were very disturbing reports of mismanagement and corruption going on at the Western Regional OTB, and cleaning up that mismanagement obviously furthers a substantial state interest. As to the reweighing of the voting power that Your Honor referred to, that implicates a second state interest, and that is that before this law, there was disproportionate representation on this board. A small county like Steuben County that has, I believe, less than 20,000 residents had the same voting power as Erie County that has roughly 1 million residents. I think it was reasonable for the legislature to conclude that the large counties and the large cities that generate the vast majority of the revenue of this entity are entitled to more weight in the
Right. Well, that sounds like a fairness issue. I thought that the state concern here, assuming we would agree with you, we also have to look at whether this law is substantially related to those concerns, to those goals. What I had read was the purpose of this legislation to address the concerns is there was health benefits being given to members of the Western New York Regional Off-Track Betting. Some generous benefits there, right? That was one. There was $121,000 worth of tickets to concert sporting events that were unaccounted for. There were, they didn't keep accurate records of those. And then you had the $3.1 million in federal COVID funds that were given, and then they still laid people up. How are these concerns addressed by just giving Erie, Buffalo, Rochester, and Monroe more voting power? How are those concerns, wouldn't it just shift the ability to do those things to other board members?
Well, Your Honor, the reweighting of the voting power of the board was targeted to a different concern. The corruption and mismanagement concerns that you just summarized was a justification for replacing the old board.
But how does this law address those? How does this law address those corruption concerns?
Well, the part of the law that replaces the old board with the new board addresses the corruption and mismanagement. The reweighing of the voting power of the new members of the board addresses a separate and distinct state interest. That is the interest in having proportionate representation. In other words, Erie County with far more population generating far more revenue should be entitled to a greater say on the board than a county that's 1/50th of the size of Erie County. That's a separate.
But they had that previously, didn't they? Didn't they have that previously? No legislation?
Well, no, I believe Your Honor might be referring to the statutory formula for distributing the proceeds of the OTB. That was unchanged. That formula is based in part on population, and it's also based in part on the proportion of revenue.
Where the bets are made, right? But with respect to the state concern on corruption, is based my understanding there was a 2019 FBI investigation into this, into the Western Regional Off-Track Betting. That was so 6 years ago. anyone ever get indicted on any of that investigation? Any charges filed against anybody?
Not to my knowledge, Your Honor. There were various other, audit reports, and no action had been taken by the old board in response to the reports of the comptroller and the attorney general.
No charges against anybody. I mean, 6 years now. The feds have been looking into it. So far, they come up with nothing. Is that fair to say?
Not that I know of, Your Honor, but that nevertheless presented a serious concern to the legislature whether or not anyone actually got indicted. So I think my opponent even sort of acknowledges that the replacing of the old board with a new board furthered the substantial.
I mean, but I guess if you're replacing the board members, but allowing the same conditions to occur, you're just allowing different board members to do the same things unless you make some other changes there. But it seems like there's a lot of allegations here of wrongdoing. I know the state controller looked into and came up with all the $121,000 of tickets. Is that any indication that that's a crime or anything wrong with that? Doesn't that happen in a lot of businesses?
Well, I guess the comptroller.
I see all these allegations. The main reason if you read the Assembly and Senate debate is corruption and yet no charges filed in 6 years. I don't see there's no there, it doesn't seem like.
I would disagree, Your Honor. I mean, the fact that these matters were brought to the legislature's attention gave it a reasonable cause to do something. The fact that a prosecutor might not have done anything could depend upon the evidence. As long as the legislature has a reasonable basis for believing that action is necessary, that is all that is required.
Have the health benefits changed? I know there's new board there and a new director. Any rules that prohibit those allegedly excessive health benefits?
The record doesn't reflect that, Your Honor. And if your concern is the new board just as bad as the old board, that doesn't go to the constitutionality of the legislature's action.
Right. I would say my concern, I'm not saying this is my conclusion, but is this pretextual? All these allegations of corruption, is that really a pretext to do something else, is to shift the balance of power to the urban areas, to the larger counties?
The Court of Appeals in the city versus state case has rejected that type of argument, and that you don't try to look behind the purported reasons of the legislature. Each legislator could have his own reason for voting for this bill. What you look to is the stated reasons in the legislative history. And we do have that in the record at page 60. We have the sponsor's memo citing the two concerns that I mentioned, the corruption and mismanagement on the one hand and the disproportionate representation on the other. And the court asks itself, are those legitimate substantial state interests that are furthered by this law? And I think the answer is yes. I mean, my opponent doesn't even argue that the corruption and mismanagement isn't furthered. He's just saying that reweighing the voting power of the board members doesn't further the mismanagement and corruption concerns, but he overlooks the separate and distinct reason for the law, which was to make the representation on the board more proportionate to the population of the residents of Western New York. That's a legitimate state interest.
Right, even though the funds get allocated exactly the same. But if your capacity argument is correct, we don't get to any of this other stuff, correct?
Well,
if you're right that the plaintiffs lack capacity to sue, the merits are irrelevant, or am I wrong there?
Well, on the home rule claims, you really can't answer the capacity claim without addressing the merits, because if they have a meritorious home rule claim, they should have capacity. The capacity argument really goes to the third claim, which is their argument about there not being a law of equal dignity. Is the legislative equivalency argument. Their argument is that because the statute that created the Western Regional OTB was the product of a standalone bill, only a standalone bill can modify that entity. But there's no support for that. The budget bill that created Section 502A became a law as a result of the joint action of the governor and the legislature. And the law is a law is a law. under the case law, what you can't do is modify a statute by a joint resolution, but one statute can modify another, and there's no hierarchy among state statutes. They all come into being through legislative and gubernatorial action. They all acquire the status of law under the Constitution, and that is enough to. As to this claim, though, this is the claim as to which the plaintiffs don't have capacity, because this doesn't implicate their home rule powers or any other recognized exception. But I would take either one, a ruling on the merits. It's so clearly meritless, or you can say they have no capacity to present this claim because, even if meritorious, it doesn't implicate their home rule powers. Now, there's one sort of misstatement in the plaintiff's brief that I need to correct. They take the position that when this law was proposed, that the governor issued what they call a certificate of necessity, and they say that suggests that the governor must have thought that home rule applied, but they're confusing a message of necessity, which is what was issued here under Article 3 of the Constitution, with a certificate of necessity. A message of necessity under Article 3 dispenses with the requirement that a bill sit on the desks of the legislature for 3 days before it can be voted on. That's what was issued here. There was no certificate of necessity. That's a separate animal, a separate document under Article 9. That was not issued here, and you can tell this by looking at page 67 of the record, which shows that what was referred to was a message of necessity, not a certificate of necessity.
Just to be clear, you're concede this is not a general law. This is a special law, right?
It would be a special law if it related to the property, affairs, or government of a local government. We say it doesn't.
You're not claiming it's a general law.
Well, we're saying it's not subject to Article 9 at all, but if it does implicate local government affairs, it is a special law. It would then be valid because the legislature can enact a special law in furtherance of a substantial state interest.
Right.
So for all these reasons, I would ask that you reverse Supreme Court's order and declare that Section 502-A of the racing law has not been shown to be unconstitutional. Thank you for your time, Your Honors.
Thank you. Rocco, good morning.
Good afternoon, Judge.
Good afternoon. I keep saying that. Wishful thinking.
Judge, Justice Lindley, and it may please the court, thank you for the opportunity to present this case on behalf of our clients, which are 6 rural counties who have been charter members of the Western Region OTB since its inception in 1973. We brought this claim because of the dilution of the power, the authority of the rural counties. While there are 15 counties in total, 2 of them are principally the urban counties, Monroe and Erie County, as part of the Western Region OTB. So we brought this case on behalf of these 6 rural counties because we believe that the Constitution, Article 9, Section 2, has been violated as a result of the enactment of 502A, which we do believe is a special law, and I'll get into that in a moment. We believe it's a violation of Section 9 of the Constitution because Section 9 of the Constitution protects, on behalf of the municipalities through the home rule provisions of this section, this article of the Constitution, the rights, powers, privileges, and immunities which are granted to these counties. There's case law which indicate that this phrase, that this grant of authority to the counties in the Constitution should be liberally construed. I find it interesting. I think that I heard Mr. Palladino concede the capacity issue as it relates to our home rule claim. So he seemed to narrow the capacity argument to the third cause of action. So we don't believe that capacity by virtue of our papers, but also of the concession that I think he's made here. We don't believe that there's a capacity issue here. There's no question that generally municipalities can't be suing the state, but there are exceptions to that general rule. And one of the exceptions is if the claim is brought pursuant to the home rule powers, which I've already articulated, or if the state's action, if the legislature's action adversely impacts
a municipality's proprietary interest in a specific fund of money. And I will.
Right, on that issue, they seem to suggest that if the amount of money varies year to year, then it's not a specific fund. And they cite some school district cases. Here, they say also the amount of money you get, you're definitely entitled to the stream of money, but it varies depending on how many people are gambling. Is that?
I think that's a matter of semantics, Judge. I mean, the specific fund is the revenue, that's the net revenue that's generated by the Western Region OTB. It's not that on an annual basis, there's other proceeds coming in, for instance, subsidies from the state or from the federal government. This is a specific fund to the extent that it's limited. The distribution is limited to the net proceeds of the revenue of the Western Region OTB.
And that net proceeds will change annually.
Those proceeds can change annually, but it's still a specific fund. I mean, it's coming from the coffers of the Western Region OTB.
But it's not specific. When you say specific, it's not specific. It's delineated. You know, you're going to get a specific amount of funds every year. It's not like that.
No, they're not guaranteed a specific amount. But what I'm suggesting, Your Honor, is that where the funds emanate from is a specific source. It comes from a specific fund in that the money comes from the same source every year.
And does the proportions change as far as depending on Orleans County has a really good year or does that percentage always stay the same?
Judge, the formula is tied to population and to the gaming activity on a county by county basis. But my argument isn't about the mechanics of the distribution. My argument in terms of how the municipalities have that their rights, their proprietary interest, their governmental interest have been diminished by 502A goes to the net amount. So
would you agree though that the home rule section was enacted to prohibit the legislature from getting involved in local issues, purely local issues? But oftentimes we can have cases where there's overlap, right?
Correct.
And you would agree that there's overlap here, that the state has an interest in ensuring prudent fiscal management of the public funds, et cetera, of this public benefit corporation.
Well, there's no question that the state has an interest because the state shares in the net revenue. And I don't dispute, given my background, I don't dispute the state's interest in, mismanagement or corruption or malfeasance. However, Your Honor, I think that we have to be very careful in the context of the home rule that when the state is attempting to address a special interest, it needs to be proportionate and it needs to be rational in terms of the goal that they're trying to achieve. I'm just perusing my notes here because there's an important quote that I want to provide to you.
Well, but that's if the home rule applies at all. And the question of the home rule applies at all. We've got Empire State Chamber of Associated Builders and Contractors, the Court of Appeals case from 2013. That talks about that you have to determine whether or not the legislation was enacted in furtherance of and bears a reasonable relationship to a substantial statewide concern. And that's why I asked that question first. Well, because if it does here, then the home rule doesn't apply.
But Your Honor, I'm arguing that there is a state interest. You asked me if there was a state interest, and I said yes. But is it a substantial state interest that allows the trampling of the home rule provisions of the Constitution? And we would argue that it does not. I want to cite. So you cited a 2023 or 2013 case, but one of the seminal cases, and it's alluded to in both the state's brief and our brief. It's the Adler decision. I think it's a 1923 case. I'm sorry.
That was the Judge Cardoza case, I believe.
Your Honor, thank you very much, because I just want to quickly cite, it's at page 23 of our brief. But in a concurring opinion, Judge Cardozo stated, quote, that for the state to enact a special law on local affairs without complying with home rule requirement, the state's interest in the subject matter must be substantial. More importantly, in order to appropriately balance state and local interest, the enactment must bear a clear relationship to the substantial state interest. So let's look at what the state says is the substantial state interest. they cite, allegations of mismanagement, maybe even malfeasance, Your Honor. You asked whether or not there have been any charges. I mean, these allegations were raised in 2019. The law was passed in 2023. The statute of limitations had almost passed by that point in time in terms of any criminal conduct by the time the law was changed. But more to the point, in 2018, so it's in our brief, it's a footnote in our brief at page 30. And I find this to be illustrative in terms of this substantial state interest. And why we think that this statute, this amendment of the statute was indeed pretextual. In 2018, the Inspector General issued a report regarding the Catskills OTB. And again, it's at page 30 of footnote 2, page 30 of our brief. The Inspector General issues a report regarding the Catskills OTB, where they found that the president of the Catskill region OTB, quoting, unnecessarily maintained several long-term leaseholds and owns a warehouse largely utilized for the storage of worthless items and garbage. Mismanaged the OTB's headquarters and other facilities. So you could read the allegations.
There that they did not do anything about it, but in this case,
they didn't do anything about. So this is a year before the reports that they're citing, the 2019 reports. And if the issue of proportionality, that's my characterization of it. Mr. Palladino might have made a more eloquent argument about it. But
about that though, about the board, makeup of the board. So your client's concerns about that is that the new makeup of the board will allow them to change the distribution of funds in the future.
Judge, for sure, the dilution of their authority, of their power, does protect or does impact their proprietary interest in the net proceeds, because the board has vast powers. Frankly, the board has the authority to sell Batavia Downs. Batavia Downs is the largest generator of revenue to Western Region OTB. By the way, it's located singularly in Genesee County, which is one of the plaintiffs in this case. So how could we say that the sale of the Batavia Downs would not in some way impact Genesee County? But
am I correct? I'm sorry, but am I correct that this new board has the sole authority to determine the future distribution, and they could lock out your counties for whatever reason and give it more to the bigger counties if they so chose?
Judge, I wish that your question was indeed exactly what's going on here. My position is that the new board has the power to affect the net revenue, which is what is ultimately distributed by virtue of contracts they enter into. So I mentioned, in the extreme, the sale of the facility, the sale of Batavia Downs, but they could enter into consulting agreements. They can enter into, public affairs agreements. They can hire more staff. They can give away, health insurance benefits. That's one of the claims that the state has made. It was part of the problem here in the first instance. So my point is, without any speed bumps from the rural counties who once had, by virtue of being charter members, without any speed bumps now, 2 counties and 2 municipalities within those counties now control the entire operation of the enterprise.
Wait, don't you only need 3 out of those 4?
I'm sorry?
Don't you only need 3 out of those 4? You don't even need all 4.
Don't even need all 4.
Right, so could they?
My clients can't even form a quorum
right.
without Erie County and Monroe County.
This formula of 50-50 of the funds, 50 based on population, 50 based on where the bets are coming from. This new board could change that if they wanted to.
No.
That's statutory. That's statutory.
That's I believe it's 518. That's statutory distribution.
So that's some protection for your client.
That's some protection, Your Honor, but it doesn't go to the day-to-day operations, which impacts the net revenue.
But the legislature can create public benefit corporations to do all sorts of things. And the legislature can set how those public benefit corporations are managed. All of them affect the revenue of the municipalities where they're operating. all of them can change it. All of them can make decisions on a weekly, daily basis that can change it. And the legislature has the authority to determine how those decisions are being made. They could say, well, we'd like the smaller counties to control more of what's going on in Erie County. So they could do the vote by every county gets their own vote. They could then change their mind. And they could say, well, now we think that's unfair. We want to have it go by population, which is what they've essentially done. Why isn't the remedy of whichever county feels like their role is being diminished or they don't have sufficient power? You lobby the legislature and you ask that they change to give you more power, the same way that any county would with any public benefit corporation. Why is this unconstitutional?
Because it's a change, Your Honor, because these are charter enterprise, these are charter members of the Western Region OTB that not only at the time of the enactment of the enactment of the off-track betting through the racing and wagering statute in 1973, that statute required that these counties enact a statute, that they pass a statute authorizing them to join the Western Region. They also made a financial contribution.
Right. I was going to ask about that because that's the argument made in the brief, but that's been repaid multiple times over.
Your Honor, if you're a shareholder in a company and you got your investment back, that doesn't mean you're not a shareholder anymore.
Right.
Nor does it dilute the authority that you gained when you made the investment. So, and respectfully, I don't disagree in terms of the legislature's power to create these special benefit corporations, but here they changed the rules, and we cannot ignore, in my estimation, that in my view. And I cite the Catskills OTB report as an example, that this was pretextual. Okay, they didn't like the existing board. Most likely, they didn't like somebody in the state legislature didn't like the then existing management. So the way to get rid of the management is to get rid of the board. And quite frankly, what I'm proposing to you, Judge, is that they could have found other ways to have effectuated this. They could have passed a statute that was not going to impact my clients by simply saying, we're passing a statute and everybody who's currently on the board, their terms expire on December 31st. The counties have to appoint new members. They could have done that. And it would not have impacted my clients' interests.
Could add term limits for board members or?
They could have added term limits. They could have had staggered terms. The legislature could have done a lot of things short of denying my clients their constitutional rights. And at the end of the day, if the state interest, as Mr. Palladino says, so he says there's two reasons: fight corruption and to make sure that, the big counties, have enough juice, the big counties have enough power. Well, if that truly is a state interest, then why didn't they change the scheme? Why didn't the legislature change that scheme across all of the OTBs in the state? Why did they single out exclusively Western Region OTB? So how can it be a substantial state interest if all the other OTBs remain status quo? And they didn't look at this proportionality of representation issue that they say is the second most important issue.
And these counties had to opt in to participate in Western. I'm from Onondaga County. Our county never opted into an OTB. They said they want no part of it. And I'm saying these counties had to opt in it originally. So now the rules are changed so that's essentially your position, correct? And that's why you believe it's a municipal home rule issue.
Yes.
Too, because they had I think the legislatures each had to pass legislation, right?
The 1973 enabling legislation required the counties that wanted to be members to pass resolutions at the county level, authorizing those counties to join. And then there was the financial contribution. So there was, and I'm not making the argument that, I know that we argue in our brief, the legislative equivalency. That's not the argument I'm making here and now. What I'm making the argument that my counties, my clients have a proprietary interest, which gives them home rule protection. There's no question in my mind that the record clearly reflects that 502A is a special law. And if it's a special law, it either needs a home rule message from the counties that are going to be impacted, or needs a message of necessity, which then so either a home rule message from the impacted communities, a message of necessity. However, 2/3 vote of the legislature, if it's a special law, is required.
Isn't there another or though, if there's a substantial state concern? If it doesn't have those things you just talked about?
You're right, Judge.
But
So then we go right back to the.
But then there's an and, there's another or substantial, and then there's an and, it has to be substantially related to that concern, and you've got questions on that.
Yes, absolutely. And I appreciate your time, and I know it's been a long morning and a long afternoon, or getting into the afternoon now, but I want to end on this point, Your Honor. You know, for all of the allegations of, you know, this being about corruption and the state's substantial interest in corruption. And I am not suggesting that there's, you know, anything remotely untoward that is going on, but intuitively, intellectually, it makes absolutely no sense to advance that substantial state interest to combat corruption or to guard against corruption by putting the power in a smaller group of individuals. We went from 17 equal votes on this board. One county, one vote, and City of Rochester and City of Buffalo all had votes. And by the way, the proportionality issue in terms of population, Erie and Monroe County, when you count their two cities, have 2 votes. Genesee County, where the facility is located, has 1. So the whole scheme
that these safeguards that they say they put in to prevent the corruption don't prevent the corruption, it just allows it to be perpetrated by other people.
It's illogical that we're going to prevent corruption by instilling power in fewer people with less oversight.
Thank you, Council.
Thank you, Your Honor. Thank you.
Thank you, Your Honor.
Last case on this afternoon is number 501 as well, Haunted Forest LLC versus Town of Wilson. Buckeye is here. Opposing counsel is remote. Buckeye, you always seem to get the last case of the day. My apologies.
Not a problem, Your Honor.
Very patient.
Just waiting for Mr. Andriozzi. There he
There
is.
he is. Mr. Androsi, can you hear us?
I can, yes. Can you hear me?
We can. All right. Well, let's proceed, Mr. Buckeye.
May it please the court, honorable justices, my name is Craig Buckeye from the law firm of Phillips Lytle, representing the town of Wilson and the Wilson Zoning Board of Appeals. Today, we are arguing 2 different appeals. The first appeal is with respect to the invalidation of a positive declaration that was issued by the Wilson Zoning Board of Appeals on May 24th, 2023. We would start out by saying that this was a non-final determination that was unripe for judicial disturbance. Because in an Article 78 proceeding, it is Hornbook law that non-final determinations are not subject to challenge. And here, the issuance of a positive declaration was simply a preliminary step in the environmental review process under the State Environmental Quality Review Act, or SECRA.
Right, but why isn't it type 2 and that's pretty understandable. You say positive versus negative deck, but when you're saying type 1 versus type 2 and whether or not it's reviewable at all is a secret matter. Why is that? Because if we follow your position on that, then it's non-reviewable. And what could happen here is what you're being accused of is that, you know, the town is just going after these people and they're making them pay for this very expensive secret review where the ag and markets law seems to apply. Maybe that's not what it should be. Not that they can't put on conditions, which they clearly can and did, but they shouldn't be required to have a secret review. What would it say?
Well, several responses to that. First of all, there is ample case law that supports the proposition that just because an environmental impact statement preparation takes time, just because there's an expense involved doesn't mean that that someone can't be required to do it. So that's the first thing. The second thing I would say is that we certainly understand that the petitioners take the position that this was a type 2 action and that there was no need for any environmental review at all. We would submit that the Zoning Board of Appeals rationally concluded that there was at a minimum at least some ambiguity as to whether there was type 1 or type 2. And the reason for that is that type 2 actions, which are listed in section 617.5C of 6 NYCRR. It talks about an agricultural farm management practice. And these can include things like digging a ditch, manure management, taking care of pigs on the farm. But here we had marketing materials that were in the record from the petitioners that said nothing about any kind of contribution of this haunted forest event to the activities and the operations on the farm. It was supposed to be a full scare attraction with horror themed excitement, nothing about doing anything to support the alleged planting and growing of crops on the farm.
But the state seems to have passed legislation that now seems to encourage this ag tourism
and so
this kind of encompasses it, although you could argue that it's more extreme.
Well, and what we would say to that, Justice Greenwood, is that yes, what I think Your Honor is talking about is Agriculture and Markets Law, Section 305-A, which would encourage these kinds of agritourism type activities. But the Department of Agriculture and Markets has issued guidelines about the construction and application of Ag and Market Section 305-A. And in particular, this is set forth at pages 273 and 274 in the record. It says that in order to have an activity that is considered incidental to some agricultural use, that two criteria need to be satisfied. First of all, the ticket sales from the event must be less than or equal to 30% of the revenue of the sales of the products that are grown on the farm. And then second of all, this agritourism event needs to be used for the purpose of direct marketing of farm products with a primary purpose of encouraging sales of those products, not as a recreational use of the land. So the town of Wilson, in the marketing materials that the petitioners themselves prepared, would have expected at least some measure of emphasis with respect to the primary purpose of the event being not only to have folks visit the farm, but also to have them purchase the alleged Christmas trees and pumpkins and squash and corn that were being grown on the farm. You look at the marketing materials, there is no mention of any of that. It's all about the scare aspects, the fright aspects. And so at a minimum, the town of Wilson presented with what the petitioners were telling them, which was, oh yes, this is absolutely incidental to the farm operation. But then they see marketing materials that make no reference to the farm operation. At a minimum, there was some discord in the record as to what the true purpose was. And the way to get at what the true purpose is by requiring an environmental impact statement. And even apart from that, in addition, when one looks at the Wilson Town Code concerning special use permits, and the provisions are set forth at 608 through 610 of the record, the town code speaks of the different criteria that need to be considered in determining whether a special use permit should be granted, even if it would fall into one of the categories, which here it would be putatively the agritourism category. And what needs to be considered apart from the agritourism aspect is, number one, is there a detraction from the use and enjoyment of the neighboring property owners? Are there issues with traffic? Are there issues with motorist or pedestrian safety? Is there a potential for an effect on the existing quality and character of the community? And there was ample testimony in the record, particularly at pages 614 and 615, from the public hearing that the ZBA engaged in on May 24th, 2023, whereby people were testifying, for example, that in the prior 2 years, when this event was allowed, that employees were staying after hours, hooting and hollering. The traffic is scary. People were throwing rocks at the neighboring houses. There was a veteran who had post-traumatic stress disorder who was really bothered by the noise because there were stage reenactments during the night while this event was taking place in 2021 and 2022. There was a neighbor who said, we can't use our own backyard on the weekends for the whole fall season. There are screams, yelling, blasting music, constant harassment. And then they added a stage with loud music. I lock myself in the house and close all the windows.
Counselor, does Judge Sedita's order prevent the ZBA from dealing with those issues, though?
It did, absolutely, because what Justice Sedita ordered on April 2nd of 2024 was he directed the ZBA to go back to the drawing board and to consider the application for a special use permit without doing any kind of secret analysis. And so, given that dictate, the ZBA decided in June 2024, because it was pretty belatedly served with the order with notice of entry. Once it was finally served on May 30th of 2024, then Justice Sedita said, I want this done all in 30 days. And so the planning board first had to issue an advisory opinion. The planning board, regardless of the dictate not to do any secret analysis, still said, we are of the view that this special use permit application should not be approved. But then it had to go to the ZBA, which had the ultimate authority. And the ZBA did end up issuing a permit with some stringent conditions. And then the event never ended up happening anyway, because the petitioners claimed that it was too late, given that they got a permit in June. Never mind that in 2021, they got their permit in August and they still had their event. But we would say that even notwithstanding the rationality and the fact that there is ample testimony in the record that supports the decision that the ZBA made, and given the fact that it's well known that in a secret case, it's up to the ZBA to identify the areas of relevant concern, to take a hard look, make a reasoned elaboration. They made detailed findings at page 616 of the record. It's not the job of the court to second guess those findings that are based upon things in the record, because it's not the job of the court to substitute its own judgment for that of the agency. Even setting all of that aside, the fact is that if an environmental impact statement had been done, there is a possibility that the permit would have been issued. And that's why the positive declaration that was overturned, invalidated, that was a non-final determination. There was no question in the code of the town of Wilson that it was the job of the zoning board of appeals to rule upon and consider and issue special use permits. And that's set forth in zoning ordinance section 127-46, which is at page 610 of the record. What the petitioners tried to do in this proceeding is to try to concoct an argument that in fact it was the town board. But the fact is, in order for an entity to function as a lead agency under SECRA's regulations, this is section 617.2 of 6 NYCRR, the lead agency needs to have responsibility to do one of three things: undertake an action, fund an action, or approve an action. Well, it was a private entity that was looking to undertake and fund, but the entity that was given the sole authority to approve was the ZBA. And so, given that the ZBA issued a positive declaration, then the ball went into the petitioner's proverbial court to do the environmental impact statement, and then they might have gotten a permit, or if they didn't get a permit, that would be the time that they could raise their challenge. So this was an unripe challenge to begin with, and even setting aside the ripeness issues, there is ample evidence in the record that supports the determination of the ZBA that a positive declaration was appropriate, because there was a concern that there may be potential adverse environmental impacts in view of what had happened when this event did take place and when the town did take the petitioners at their word in 2021 and 2022. And even if it could be said that there wasn't enough there, the fact is, when there was another hearing done at Justice Sedita's behest in June of 2024, there was still more information elicited, particularly about the limited number of plantings on the site. And this is set forth at pages 716 and 717 of the record, because there was a question and answer colloquy about, what are the crops that are grown on the site? And in fact, what was testified to was, well, Haunted Forests LLC itself decided to stop growing anything on the site. The owner of the site, Tracy Quinn, has done some growing, but it was nebulous as to how much growing was actually going on. So further, this creates at least a question in the mind of the ZBA as to whether this event can truly be considered an agricultural farm management practice, and therefore creates at least a question as to whether this can truly be considered to be type 2. And there's ample evidence in the record that it wasn't. And that's why, at a minimum, even if the initial positive declaration was properly invalidated, then with respect to renewal should have been granted to allow the ZBA to undertake the environmental review process that Justice Sedita would not allow the ZBA to undertake. The second aspect of this appeal relates to the issue of a lack of filing and service of a summons and the lack of service of a notice of claim. There is no dispute that when this proceeding was brought, it was brought as a hybrid Article 78 proceeding and declaratory judgment action. And this court noted only 2 years ago in matter of Hudson versus Town of Orchard Park Zoning Board of Appeals, Justice Montour was on the panel, that in a hybrid one of these proceedings, separate procedural rules apply to the Article 78 aspect and to the causes of action that seek monetary damages and declaratory relief. And in fact, there are 3 different opinions that we've cited, 2 from the first department in our brief and 1 from the third department, all of which stand for the proposition that when one has one of these hybrid proceedings, you need a notice of petition for the Article 78 part. You also need a summons for the plenary causes of action. And if no summons is filed or served, there is no subject matter jurisdiction with respect to those causes of action. Now, Justice Sedita reasoned when we brought this to his attention that these issues were waived. And admittedly, we came into the case late as co-counsel for another firm that had handled it for the first several months. But the problem is these are defects of subject matter jurisdiction, and defects of subject matter jurisdiction can never be waived and are not waivable. And in fact, even if the parties were to agree, we'll let these go. It's the job of the court to step in and say, no, either there's jurisdiction or there isn't. And that's the message from the Caffrey case from the second department in 2018. And in fact, this is an issue that we can raise for the first time on appeal. And even if the parties wouldn't raise it, the court could raise it itself.
We've done that before.
And this court did do it in Molden v. White in 2009 and in several other cases. And we would ask that the court do that again. So this is with respect to, just to be clear, the plenary damages causes of action, which are numbers 4, 6, 7, 8, 9, 10, and 11. All of them should be summarily dismissed because of the lack of filing and service of a summons. That is what is required by CPLR 304. And if the petitioners have a problem with that outcome, albeit harsh, their remedy is with the legislature rather than with this court. And likewise, there was never service of a notice of claim. That's an additional reason to dismiss as well.
Thank you, Counsel. All right. Counsel, you may proceed with your argument in response.
Thank you, Your Honor. May it please the court. My name is Justin Andriozzi, and I'm here on behalf of respondents to the appeal, Haunted Forest LLC and Tracy Quinn. There were obviously a lot of issues covered in that initial portion. If there's anything that the court would like me to address at the start, I'm happy to do it. Otherwise, I'll proceed in the manner that.
I will just say before you start, we have read your brief, and I know you covered a lot of those issues as well. So we will be, anything you don't cover today, we will still have in front of us.
Okay, understood. Thank you. So one point I'd like to make at the start is Mr. Buckeye in his argument references AML 305-A and these startup farm or these ticket sale requirements for farms. He leaves out the guidance from the Ags and Markets Department regarding startup farm operations. Of course, for my clients transitioning from a horse farm to an agricultural farm, they planted a whole bunch of Christmas trees and were trying to get their farm off the ground. And when you do that, you have to let the crops grow. And the Ags and Markets Department provided guidance stating that those ticket sale requirements do not apply until your crops that you grow reach maturity. So any of those ticket sale requirements wouldn't apply in this case per that guidance. Now, with regards to the ripeness question, the appellants raise the argument that matter of Ranco Sand and Stone Corporation v. Vecchio drastically narrows the Court of Appeals determination in matter of Gordon v. Rush. So much so that this court can no longer pragmatically evaluate an agency action to determine whether it imposes an obligation on an applicant that inflicts actual concrete injury. Contrary to that assertion, the Ranco decision does not narrow Gordon, it reinforces it. The test requires the court to perform a pragmatic evaluation and states that the agency actions imposing an obligation on the applicant are ripe for review. The Court of Appeals stated in Ranco that Gordon was ripe for review because no apparent, and I quote, no apparent further proceedings would remedy the injury caused by the unnecessary and unauthorized expenditures associated with conducting a DEIS. That's the same thing that happened here in our case. The record shows that appellants intentionally delayed due process. They did not follow proper secret procedures. They applied errors of law, which resulted in arbitrary and capricious positive declaration. And the ZBA caused respondents in this case to not only incur unnecessary expenses associated with conducting this DEIS, but came at a time where it prohibited respondents from operating their event, inflicting substantial, actual, concrete injury. Simply put, appellants' argument creates an unnecessary financial barrier to justice. They claim that a municipality can do exactly what the Supreme Court, in this case, correctly admonished appellants on the record for doing. They use SECRA, and I quote, as a sword to thwart respondents instead of as a shield to protect the environment. And the aggrieved applicant in this situation cannot challenge the erroneous determination. This is ripe. For a startup farm operation facing financial hardship, a determination that prohibits income by shutting down operations and requires completion of a time-consuming and costly environmental assessment must be ripe for judicial review. Otherwise, you're going to leave yourself in a situation where petitioners, plaintiffs around New York State with valid causes of action have this financial barrier to justice on a justifiable claim, like the Supreme Court in this case pointed out. My clients are trying to operate a corn maze and a hayride event for 90 hours a year, 18 days a year. It's a corn maze and a hayride. Appellants in their argument point to a couple pages of the record where there's some complaints from some local residents. Those complaints started before my clients ever opened their event. There were a couple press releases, some marketing materials that went out talking about my clients partnering with Niagara Pride and some other local organizations to try and create a family-friendly event that was inclusive and helped build the community and raise much-needed funds to market their farm. Immediately after that, a couple of these neighbors started making accusations. And Mr. Buckeye points to some of those accusations that were later refined to be light pollution and noise. But the accusations that came from those same residents, the initial ones, were over fear of child molesters and predators and fear for the safety of their children because of strangers coming to my client's farm to go on their hayride and corn maze. These were completely unsubstantiated, and they led to the town unethically targeting my clients and shutting them down. And you don't just have to take the community members who came to support my client's word for it. The town's own code enforcement officer submitted an affidavit in this case after leaving the town, admitting to the corruption and the unethical conduct, testifying to the fact that under oath that he was approached by town officials telling him that he needed to shut down the haunted forest after he told them, monitoring the haunted forest in Miss Quinn's property, that they weren't doing anything wrong. They were not loud, as the community members also stated on the record. There was no noise or light pollution. None of these things happened, and the code enforcement officer explained it. And they told him, shut him down, make something up. That's the exact quote on the record. This is a case of municipal corruption and targeting a small startup farm for the way that they wanted to operate their business. The Supreme Court reviewed the record, sniffed it out, identified it, and admonished the town for what they did. He made comments about affidavits that were filed by town officials that were not, in his view, credible, I'll stay on the record, but it is important to say that in depositions, these things have been flushed out as well. But this case, it has its own set of facts. And the facts of this case that are on this record show that the town's own code enforcement officer corroborated the fact that there was unconstitutional, unethical actions, that my clients were hindered in their due process, and that they were prevented from operating by nature of delays and then use of SECRA as a sword to thwart my clients, as the Supreme Court correctly stated, and not as a shield to protect the environment. So, Your Honor, for that reason, I think any suggestion that that type of conduct and that factual basis is not ripe for adjudication, I think is disingenuous. And again, as I stated earlier, creates a financial barrier for justice that there's no rational basis for it. I will jump ahead now to address the issue of the summons that was not filed in this case.
Briefly, if you would, your time is running quite short.
Okay. So, I think our brief covers it pretty well, but I do want to point out that the cases relied upon by appellants are not cases. These are cases where the claims were brought in the entirely wrong court. For instance, the Fierro case, the Court of Appeals correctly reversed a Supreme Court decision regarding Securities Act issues. And they reversed it not because there wasn't a summons filed. They reversed it because in the Securities Exchange Act, Section 27 of that federal act expressly states that the district courts of the United States, the federal district courts, shall have exclusive jurisdiction of Securities Exchange Act violations. So the case was brought in the wrong court. Here, we're in the right court. We filed our hybrid petition/complaint. We served it. We provided a petition, which case law state, or a notice of petition, which is the functional equivalent of a summons. And respondents were put on notice of every claim that was there. Respondents asked for an extension. We consented to it. The court gave it to them. They then, months later, filed their motion to dismiss and never raised any issue about us needing to file both a summons and a petition. The Supreme Court, all over the record, refers to this as a hybrid proceeding. Courts have converted sua sponte petitions to hybrid petitions or to consider plenary causes of action, and haven't gone and said, okay, I'm going to convert this because I have jurisdiction to do this, but you have to now go back and retroactively file a summons because that's what's required. The CPLR, I think, admittedly, doesn't cover these hybrid proceedings, although the courts encourage them because of judicial economy and not having to have both a Article 78 proceeding and a separate lawsuit that is under the same facts and circumstances. But I can give you a bunch of examples. One, I would say Section 105 of the CPLR under definitions.
Would be good.
I'm sorry?
I think maybe one example might suffice.
Just one then, Your Honor. The definition, Section 105, subsection B, action and special proceedings. That section states that the words summons and complaint include the notice of petition and petition, respectively, in a special proceeding. These documents, these notice documents are functional equivalents. And I find it, the precedent that can come from allowing a defendant or respondent in a case to not raise any of these arguments in their motion to dismiss, not raise them in their answer, wait as long as they possibly can until the claim runs stale or the statute can expire, and then raise it and it be allowable and those causes of action be dismissed. All that's going to do is encourage and in fact, make it best practice for defendants and respondents to not raise these issues in a timely manner where justice can be, where you can amend, refile, or have this cured, and strategically drag it out and wait as long as possible, only to raise it when it, at a time when it's not able to be remedied. And I'm not saying that that is necessarily the case here, but there's plenty of examples. You know what, Your Honor, I know I'm short on time. If there's any other questions, I'd be happy to answer them.
Thank you, counsel.
This court will stand in